Yep, you're live, so, and I have your audio on, so.
Oh, welcome. All right. Well, good evening, everybody. It is 6:30 on my computers. I have 6:29, 6:30, and 6:31. So we'll go ahead and call it 6:30 and get started. I am super excited for tonight. Let's go ahead and start with a roll call. Kelly.
Okay, Commissioner Crosby,
Here.
Commissioner Lee,
Here.
Commissioner Malone,
Here.
Commissioner Zawowski. Is that
Here.
correct?
Yes, sir.
Okay, thank you.
Here.
Commissioner O'Leary,
Present.
Commissioner Pullen,
Present.
and Chair Wagner.
Here. Thank you very much, Kelly. Moving on to our first item on tonight's agenda, we have approval of our minutes way back from November, the 25th. I think there are only 4 of us, which means just enough, I think, for a majority. If there's folks that have any edits, go ahead and let us know now.
Nothing.
All right, not seeing anything, we'll go ahead and consider those minutes approved. And now we'll move to requests from the floor. I don't see anybody in attendance in either the Zoom meeting or in the building, so speak up real quick if you're wanting to participate. Otherwise, we'll move on to Kelly, your director's report.
Oh. Thank you, Chair. So I was just gonna cover a couple quick things on this report. So the only upcoming meeting that I have everybody invited to at this point, and I believe you received an invitation to it, was the joint work session with City Council on February 18th, and that starts at 6 p.m. And that will be discussing mass timber. I believe I provided a short little blurb when I sent the invite, but basically what happened is the state of Oregon had a grant that they received from the federal government to award up to 10 different cities and counties. I had applied for it through DLCD about, I think, a year and a half ago now. And basically DLCD then selected a consultant. The consultant, which was MIG for us, who we've worked with in the past in the clear and objective audit, they actually worked through our code, and they're going to have a set of recommendations that they'll be bringing forward on February 18th. And those recommendations are would help with any mass timber applications that the city of Sandy receives. And you'll be learning more about mass timber on the 18th of February, but basically it's not new, but it's a newer form of how you do construction. And one of the big benefits of it is they haven't really figured out how to have huge savings on it yet, cost wise, but it is being used in areas that have a lot of disasters. So from hurricanes or floods. My guess is that some of the housing down in LA that was unfortunately burned down in the last week, I'm sure some of that will be mass timber. They can just produce the housing at a much quicker, rapid speed. So when you lose, say, 10,000 plus houses, like just happened in Allison and Anaheim, they'll be able to come in at least and produce a lot more of them quicker. So that's what the grant was for. Sandy was one of 10 municipalities selected. We're the largest actually of all 10. And we're the last one. I'd asked to go last so that
We're
they can.
possibly closer to no more moratorium or whatever.
Well, and also because I was hoping that as they work through the other 9 jurisdictions, that they would kind of learn.
Get the bugs out.
Yes, exactly right.
We'll benefit
so-
from their,
That's exactly
Going-
correct. So
from
that was
going
my
last.
theory. I think it did work that way. So I'm excited to hear more from them on February 18th, and I hope you all can join.
Isn't there a manufacturer in Estacada now?
I've heard there is, and I've heard there's a second one down in Eagle Creek, and then
Oh.
there's several in Portland as well.
I think the problem in Palisades not gonna be the lumber they use for it, but the labor.
Yeah.
They're not gonna have enough labor to rebuild 10,000. I mean, it's gonna be tough.
Yeah, no, I totally agree. So if you can make that on February 18th, I hope you all can. You can join by in person or online, just like tonight. And then after that, I think we don't have any hearings scheduled right now because of the moratorium. But based on the work plan that we come up with tonight on our last item, I'm planning on talking to whoever the chair is, whether it's Chair Wagner or whoever else you select tonight, on kind of a schedule on creating some other meetings going forward. Also in my report, I included a year-end report for all the code enforcement cases. Chris Aurelia, our code enforcement officer, closed 451 this year, so that's quite a few.
Yeah.
And then we had unfortunately, a few that had big citations. I just included that information below the graphic. And as you can see in the graphic, about a third of our code enforcement complaints that Chris deals with. This wouldn't include things that the police department and Kevin Moody are dealing with, but about a third of the cases that he had last year were noxious vegetation. So as you can see, that takes up a fair chunk at this time. And then Patrick put together, Patrick Depo, who's our senior planner here sitting. I don't know, Patrick, if you want to say anything, but Patrick's been with us for about 1.5 years now, and he put together some information on 2 things he's working on, one of which is the disinfection building and pump station upgrade, which is a city project. And the other one, which is also a city project, which is Deer Point Park. They submitted for a design review, and Patrick's working on that application. He'll also be working on the disinfection building and pump station upgrade to the revenue reservoir. And then, you know, just so for the new commissioners to know, we have a lot of smaller things that we work on that I usually don't put in these reports because they're kind of more like, if we do land use review on like a temporary use permit or a tree application or something like that, I usually won't include it.
Or my tough shed.
Or your tough shit.
Yeah.
Building permits, we usually don't include too much information on that. And then typically, we have a lot of other stuff we process, what it's called like Lux forms, which is land use compatibility statements. We have zoning verification letters, stuff like that, which Patrick does a lot of the heavy lifting on that. We just don't include that in the packet, but that's just other stuff we're working on typically. With that, that's.
I was just curious if you could, oh, sorry, go ahead, Patrick.
I just wanted to add one thing about those 2 items that Kelly had mentioned. The Deer Point Park, which we're reviewing right now, is scheduled to be built this year. So, you know, go from this point to engineering plans and then construction. But the disinfection building found out that it's not scheduled for construction until the fiscal year 2027.
Oh, my goodness.
And that's due to, I guess there's some upgrades to the Portland Sandy connection water mains that need to be done first. So there's some stuff that has to be done first. So they've just pushed it off. We're just getting it out of the way. Hopefully it won't need any type of renewal, but it's scheduled for 2027.
I'm guessing, I don't know all the intricacies of it, but I'm guessing there's also probably some stuff around like the loan or the lending that the city has to get. The land use is probably a requirement.
Financing, yeah. Financing can be an impediment procedure.
I was curious how the switch to electronic plan review is going.
Well, actually, I should have included that. Thank you, Chair. So we by statute are required now to take in building, plumbing, mechanical, basically any trade permits through electronic plan review, which just went into effect on January 1st. So 12 days ago. And the city of Sandy has been doing electronic plan review and intake permits through land use now for, I believe, 3 or 4 years. 100% electronic. So we don't have physical folders anymore. As Linda and Jan and Jerry, you remember like the green folders we used to bring in here. We don't have those anymore. We've gotten rid of all that. It's all electronic now. On the building division side, we have never done that. We were kind of forced to by a new state statute. And so we just started intaking things on January 1st. So far, we haven't had much submitted.
Well,
We did buy a very expensive plan table. It's like an $8,000 table that you can actually draw on and do all these things on. And we also just executed a contract with Safe Built LLC. They're a national building department consultant group. And so our current building official, he's a one-man show. He had asked me, he was rightfully so very nervous about the electronic plan review because we'd never done it. And so he wanted to hire this consultant group that could kind of back up and assist him when we get a lot of them in. So we will be using that consultant group as well.
until
So the answer is we haven't really done much yet, but we're all ready for it.
Ready to go.
Yeah, we're ready to go.
Now, does that, that would be applicable to just an individual to like, I mean, I can see an architect and so forth, but say you talk about your tough shed, you know, you want to put it, you have to show where it is on your property, just myself. So I would just do it, PDF it, and that's,
So that's actually a good point of clarification. We're still allowing and encouraging, for now at least, until we understand the system better, for in-person or physical copy submissions.
okay.
We're not making anybody do any electronic submissions. We just have to process it that way if somebody chooses to submit it that way.
Oh.
So like the tough shed idea,
I just.
I would
Google
actually
map
tell
it.
most homeowners, just come and drop it off at our city hall and we'll help you out.
It
But
was a very painless process.
yes, national builders like Holt Homes or somebody, they're gonna probably choose the electronic plan review route.
Yeah,
And the reason why is like, or for example, the new development north of Bornstead Park Cascade, the architect's out of Tacoma.
mhm,
So I don't think in that case, he would have probably submitted anything hard copy. It would have probably all been electronic. So I'm
okay,
guessing most of what we'll receive electronic, at least for the first year or two, will be national builders or really
that
large
makes sense.
Northwest builders. I don't think many homeowners probably are gonna go that route.
But you can easily convert their things to electronic anyway.
We can't.
All right, it's not on the agenda, but I see Counselor Mayton in the meeting. If he wants to let us know about the exciting world of city council. If there's any updates there.
Very funny, very funny. Hi, everyone. Counselor Chris Mayton here. Just wanted to say welcome to 2025. I don't have any new and exciting information as the chair represented from the council, but I am happy to be here and hoping to stay your liaison this year, but we will find out at the next city council meeting because I believe our new mayor is going to be announcing the assignments for all committees going forward.
Thank you, Councilor Mayton. All right, we're moving on to planning commission chair and vice chair appointments for 2025. To the floor, Jim.
Yes, I move to appoint Commissioner Wagner as chair and Commissioner Crosby as the vice chair of the Sandy Planning Commission for the year 2025.
I would second both those motions.
All right, let's do this quickly, I guess. We have a motion from Commissioner Lee, and a second from Commissioner Malone. All in favor?
Aye.
All opposed? Motion passes. Now the moment we've really all been waiting for tonight. I think we'll turn it right to Josh, I think, for our land use training. Unless Kelly has anything he wants to preface it with.
I just wanted to say, I got some hard copies. I know you have it in your packet. But we wanted to print out some hard copies so you could take some notes and then ultimately take these with you. Or just have them to refer back to. Because, you know, sometimes these electronic
Thank you.
Well, thank you for thinking.
files just get buried in your emails,
Okay.
so. just wait.
Thanks, appreciate it.
I'll put it in my other big binder.
The only thing I was gonna say before Josh takes away is that typically in the past, I tried to have these every year or two. I guess I failed to do that because I learned a month or two ago that I guess we haven't done one of these in 3 or 4 years, so my apologies. But going forward, I'll work with Josh on a more regular schedule of doing these. So, thank you.
Great. Well, good evening, everyone. This is, as you know, an opportunity for some training on land use issues for all of you. My name is Josh Soper. I'm with Beery, Elsner and Hammond. I'm city attorney and also a land use attorney. So I cover both of those issues for the city. And I'm just going to dive right into it here. But I do want to say that we're going to cover a lot of different material this evening. And so you do not need to try to hold your questions until the end, because the topics that we're going to cover will be changing rapidly over the course of this, and you may forget something. So feel free to interrupt me at any point, and I'm happy to answer questions as they come up. And then again, at the end, I'll also give you an opportunity for questions. So this is just an overview of our agenda for the evening. Going to start with a brief overview of some basics of land use. Going to dive into a number of important issues for you to deal with. And then at the very end, I've got a link to some resources for further reading if that's something you're interested in. So we've had land use law in Oregon for over 50 years now, starting with Senate Bill 100, which was adopted in 1973. And Oregon's really paved the way and charted its own path in terms of how it deals with land use as compared to a lot of other states in our country. The concern back in 1973, when Senate Bill 100 was adopted, was primarily with protecting farm and forest lands and preventing sprawl. If you read any of the media coverage from the time or look at any of the testimony at the legislature, it was there's a lot of concern about what people were seeing happening in California and wanted to make sure that didn't happen here. So nothing's really changed in the last 50 years in that respect. But it was really a kind of a interesting historical moment where a lot of different interests came together around this idea of protecting farm and forest land and preventing sprawl. You had, across the political spectrum, you had the Republicans and the Democrats coming together. You had rural folks and urban folks all kind of uniting around this vision of preventing sprawl and protecting farm and forest lands as an important part of our economy and our environment. And so the purpose of land use law in Oregon, in a nutshell, is to try to achieve a variety of different competing and complementary goals. Protecting livability, promoting economic development, protecting resources, and just overall contributing to having an efficient and orderly use of the land of our state. So talk a little bit about the role of the state and the role of cities in land use law to kind of get a better picture of how Sandy fits into that broader scheme. The state of Oregon has adopted 19 statewide planning goals, which guide the overall statewide land use planning system. There are also state statutes that are adopted by the legislature and administrative rules that are adopted by agencies to implement those rules. The primary agency at the state that's tasked with land use issues is DLCD, the Department of Land Conservation and Development, which is governed by LCDC, the Land Conservation and Development Commission. It just took the same letters and put them in a different order.
Alphabet soup.
To make it as confusing as possible. Yeah. And then the other major statewide agency that you encounter in land use issues is LUBA, the Land Use Board of Appeals, which serves a few different purposes. I mean, they hear appeals of, as the name suggests, appeals of land use decisions from cities and counties. The idea behind LUBA and what has been, I think, mostly successful with LUBA was to take those land use appeals out of our regular court system, at least as the initial place where those appeals go, in order to have people with more expertise in land use issues hearing those first round appeals, and also to avoid overburdening our court system with the volume of appeals that can come out of land use. And so that's what LUBA is for. Cities, on the other hand, then adopt comprehensive plans, which is the kind of the high level policy and vision and generally maps for how they're going to implement land use in their community. And then ordinances, which implement the details of that broader brushstroke comprehensive plan. And then the major role that you will probably see most often, although not as much right now with the moratorium, but is reviewing development applications for compliance with the ordinances and the comprehensive plan. Generally speaking, you can divide the types of land use decisions that you will encounter as a planning commission into two big buckets, which are legislative and quasi-judicial. And I'll tackle each of those starting with legislative decisions. The line between legislative and quasi-judicial can get a little blurry at times, but in general, legislative decisions involve the adoption of more generally applicable policies and standards that will apply to a variety of future factual situations in broad classes of people. And so the kind of the framework and setting the rules for then the quasi-judicial decisions that will follow that are development applications generally underneath those legislative decisions. So examples of legislative decisions are amending the comprehensive plan, zone changes that apply broadly to large areas, changing the development code to include or delete specific uses in a zoning classification, that sort of thing. Because a legislative decision is an expression of policy, city is not required to actually make legislative decisions. So when there's a proposal that comes forward, it's possible to just say, we're not going to do anything with this. As distinct from quasi-judicial, which you'll hear about in a few minutes here. And bias and ex parte requirements do not apply. So if you think back to civics class or the basics of the structure of our country's government, and you think about the three branches of government, the legislative, the judicial, and the executive. You will, in some ways, act in multiple of those roles because those three branches fall apart at the local level. And so this is when you're acting in that legislative capacity. So if you think about what Congress or the state legislature does, they're making the laws, and that's what you're doing when you're making a legislative decision. And so just like with members of Congress, bias doesn't apply because you're allowed to come into that process with your biases, and sometimes people are elected because of their particular biases. You're allowed to have particular desired outcomes.
Their biases are a lot of times why they're doing the particular
Exactly.
legislative action.
Yes, right. And then ex parte requirements don't apply. Just you think about all the lobbying that goes on in Congress or in the state legislature. That's perfectly allowable to have these conversations that kind of inform outside of the public process that inform your decision-making in a legislative context.
May I ask you a question?
Yes, please.
There's a lot of land use coming up in this legislative session, including farm and forest. And I wonder, does your firm track legislation on behalf of your city clients?
So I wouldn't say that we do like a comprehensive tracking of all legislation that affects cities the way that the League of Oregon Cities does. That's really kind of one of their primary functions. We represent the League of Oregon Cities, our system, with a lot of legislative issues, and so we get involved in those. But we don't do the comprehensive everything that's going on at the legislature related to cities. We do tend to track in particular land use issues and try to keep our clients updated on those. And then some other key pieces of legislation where we think there's really something that you need to be keeping an eye on here, or after it's passed, something that you need to be doing to respond to it. We try to keep all of our clients updated about that. We have a email list that we send out those kinds of updates to remind people of, you know, this is going into effect this date, or this just was enacted, or that sort of thing.
Thank you.
Yeah.
And I'd say you even go a step beyond that at times when there's kind of a confusing subject matter, like the recent issues we were having with interpreting FEMA's
Yes.
requirements.
Yes.
But they hold our hands on complicated issues.
And one thing we do try to do, because, you know, we represent, I believe it's now 26 cities. As their primary city attorney, and then
10%
more if
of
you
the
add ones
cities
that
in
we just.
Oregon, almost 10%. Yeah.
And then a number of additional cities, counties, and special districts as either just land use or a number of other subject areas. Try to help make sure that to the extent we can, I mean, obviously it's up to individual clients how they want to respond to different situations, but trying to have a collective response or some uniformity in our response. So for example, on the issue that Kelly noted, we put together kind of a comprehensive guidance memo and shared that with all of our clients, so that all of our clients were getting the same information, and generally most of them took the same approach to the issue. The safety in numbers, I guess, is another way to look at it too. Yeah. So for quasi-judicial decisions, to contrast with what we were talking about with the legislative decisions, when something is a quasi-judicial decision is when the application involves only a single property or a small group of properties. The decision on the application is based on pre-existing criteria. And the result is that the city is then required to make a decision. So if somebody submits an application to you, they want to, for a subdivision, for example, you don't have the choice of saying, we're just not going to do anything with this. We have to either approve it with conditions, or deny it. You're required to reach a result. And so going back to that separation or the branch of the government concept, it's helpful to focus on this word judicial and quasi-judicial and realize that when you're making these decisions, you are acting in many ways like a judge. And so that's why you are expected, just like we expect all of our judges to be unbiased, to not have ex parte contacts outside of the formal proceedings. And you have to apply the law to the specific facts. You're not making the law at that point. That's why this is something that, as you know, is often very frustrating to members of the public who come to a quasi-judicial hearing, and they don't like the rules that are in place that you have to use to make that decision. It's frustrating to hear that this isn't the opportunity to change the general rules. We're stuck with what these rules are, and we have to apply them to this particular case. And so that's why, as I noted, that these other protections apply that don't apply in the legislative
So
context.
changing the rules would fall under legislative.
Exactly, yes. Right. So bias is one of the major requirements that I mentioned that apply in a quasi-judicial context. And that exists when the decision was the product of either a positive, negative, or negative bias on the part of the decision maker, rather than an independent, unbiased review of the facts and the law. And so the standard that LUBA and the courts will apply is whether the decision maker prejudged that application or whether they reached a decision based on just the evidence in the record and the applicable criteria. And bias can be very difficult it's a simple concept in theory. It can be very difficult to wrap your head around in particular in the details. And so this is one where I'm going to dive into just giving you a few illustrative examples to kind of show you the bounds of where LUBA says bias does and doesn't exist. So this first example is an example out of Depot Bay. And in this situation, a city councilor, before making a decision, had sent a letter to the mayor and other councilors concluding that the applicant did not have the right to use the structure for the proposed use. Not surprisingly there, LUBA found that person to be biased. They formed an opinion regarding the result of the ultimate result of the decision that they're supposed to be making prior to even receiving evidence during the proceedings. And it's clear that they have prejudged that application. This case out of Cottage Grove, city councilor had signed a letter to the editor encouraging the project opponents to leave town. Also requested police logs regarding the project's opponents and added them to the record. Again, not surprisingly, they were biased, but the letter to the editor probably would have been enough on its own. Maybe not. Probably would have. But the emphasis that LUBA drew in this case was that the role of the decision maker isn't to develop evidence; it's to consider the evidence that is put in front of them and apply it to the to the criteria. And so it was that requesting of the police logs and putting it into the record that was like the linchpin in that decision. And that may seem like an obvious thing that you shouldn't be doing. But I have seen, I'm not going to name any names here. It's not Sandy, but I have seen other in city council or planning commission settings, especially now that we have a lot of remote or Zoom-based processes, where I've seen some decision makers, they are looking things up online during the course of the hearing and saying, I just found an article that says XYZ about that's relevant to this decision. That's developing evidence. That's not your role. Your role is to let everybody who wants to bring evidence to you, you consider it, you weigh it, and you make your decision. You should not be doing any of your own research, as much as it is tempting in an era where we have all the information available at our fingertips. It's important that you're not doing that. This case out of Jacksonville, this one sometimes surprises people. This was where a city councilor was a member of the church that had applied for the conditional use permit. And they expressed during the course of the proceedings some concerns about the conditions that were being recommended to be imposed on the church, but ultimately voted to approve the permit. In this case, LUBA found that the decision maker, the city councilor, was not biased. and despite being a member of the church that was the applicant. And the the key here in this decision was that the decision maker had declared, that acknowledged the situation that could lead to a perception of bias, had declared that they were going to, nevertheless, they believed that they could render an unbiased decision. And they conducted themselves in the hearing in a way that demonstrated that they were applying the facts to the criteria, not prejudged the application, and made the decision on that basis.
Do you think if she'd voted the other way, they would have found differently?
You know, it's possible. You know, I've seen cases that have gone the other way too, though. You know, I think I don't want to encourage you to read too much into this case, because my advice, generally speaking, is aside from what may or may not actually end up holding up at LUBA,
Right.
perception is also important.
Whatever you think other people may think you're biased for, you should declare it and say, no, it won't stop me from being unbiased.
Well, so a few different levels to this, I guess, to dive into it a little bit. Generally speaking, I think in most situations, if there's even a perception of bias, the best practice is to recuse yourself, because it gives people more confidence in the fairness of the proceedings. And it absolutely prevents there even from being an appeal to LUBA on that basis, where we don't have to go to LUBA and argue about it. You've completely taken that issue off the table.
As long as you have a quorum.
Yes. But that being said, if you're not going to do that, the next best thing you can do is to acknowledge the situation publicly, state your intention, your ability, that you believe that you can still make an unbiased decision, and demonstrate throughout the course of the proceedings that that's what you're doing. And generally speaking, that's not necessarily going to stop somebody from making an appeal to LUBA, but that's going to at least get us to a point where we'll be able to defend it at LUBA. I love this case because I learned a new acronym when I read this back in 2016. This is a case where a petitioner had challenged a city decision to approve a plan amendment, zone change, and master plan based on a city commissioner's reference to some project opponents as bananas, which stands for build absolutely nothing anywhere near anything. It's the more extreme version of a NIMBY.
NIMBY.
NIMBY is not in my backyard. You can build these things, but just not in my backyard. Banana is don't build anything anywhere near anything. And perhaps surprisingly, perhaps not, LUBA said that's not enough to demonstrate bias. That's more of I guess maybe more of a general statement of your philosophy
I know we
on
have
life rather
yeah.
than demonstrating bias to that particular application.
I know from reading Facebook and different things in town that we have some people who would be banana proponents in our city. No matter what, they just, once they got into town and built whatever they wanted, they don't want anybody else to do the same.
I think we see a lot of that in the smaller communities where people value the small town feel, but don't recognize the fact that before they got there, it was even smaller, right?
We had a previous city councilor, Donna Allen, at a very contentious hearing that we ended up having to move to the high school to hold it because there were so many people, and people kept coming up and saying, I want you to quit letting people into town, you know. And he said, well, you've only been here 10 years. Should we have closed it before you got here? Or, you know, it's like, you gotta have an open mind.
Can you explain on the two that LUBA decided there was bias, what then occurred after that?
You know, I don't remember off the top of my head, but generally speaking, what happens when there's bias is it's remanded to the city to make a new decision without that bias. So it'll either be that city councilor excludes themselves, or there's something done differently at the decision-making process to show that there's not bias.
So I guess my point on that was that if somebody does potentially have bias and they still are part of the decision making and then it goes to LUBA, one of the things we're potentially putting at play is that it's just going to be kicked back to the city for another decision.
Yes, and so if this person insists that they want to participate, it goes to LUBA, gets determined there's bias, it's remanded, and then they don't get to participate the second time around.
The person who appealed it to LUBA could still end up with the exact same decision.
They could.
They
Yeah.
could. It doesn't necessarily change the decision. It just changes who gets to participate the second time around.
That's absolutely right. Any other questions about bias before I move on to ex parte contacts? So the definition of an ex parte contact is any communication or information that's received outside of the record in a matter that's pending before the city, and that can include site visits. The important thing to remember here, and I caveat that, I'll caveat this in just a minute, but ex parte contacts are not unlawful. It's not illegal to have an ex parte contact. What is problematic is that you have to, if you don't disclose that ex parte contact. And so the idea being that everybody who is participating in the proceeding needs to know what information is forming the basis of a decision and have an opportunity to respond to that. And so if you have any ex parte contacts, that's okay. You just need to disclose at the hearing that you had an ex parte contact and the substance of that ex parte contact. And that's what really trips people up most of the time, is the substance. So I'll see a lot of times where people will say, I had John Smith came up to me in the grocery store and told me that he's opposed to this application. Or he talked to me about this application, but sometimes they go as far as to say, and he's opposed to this application. That's not enough. You need to disclose what he said to you and the substance of that communication. Why was he opposed to that application? So that people can have an opportunity to know what you heard and to be able to refute or respond to that information. That can be really difficult to do, to remember the substance of the communication, especially if you have a lot of different communications over a period of time, which is the caveat that I was referring to earlier. For that reason, I strongly encourage you to avoid ex parte contacts as much as possible, even though it's not unlawful, just because it can be really difficult to comply with that disclosure requirement. There are a couple exceptions. Communications with staff are not ex parte contacts. You're allowed to talk to them about applications as much as you want. And communications before the application is submitted or after the final decision is made. As I note there, more on this later. Kelly kind of alluded to it a little bit here when he's talking about remands. When you make a final decision, that decision may end up coming back to you. And so until you're sure that that's not going to happen, you got to continue avoiding ex parte contacts.
Can you talk a little bit about electronic forms as well, like maybe Google Maps and Facebook?
Yeah, I mean, yes, that's a very good question. Google Maps, Facebook, social media, anything, any communication or information received outside of the record in a proceeding, regardless of the form that it takes, that's an ex parte contact.
And I was thinking how it could be passive. Things can come at you without you even intentionally going to look for them. Like Facebook is the thing, you're just scrolling down and there's something, and to just declare, I saw it, I didn't read it or whatever.
Yep, it can be difficult to do that. And I guess it kind of dovetails in with what I was saying earlier about doing your own research, right? If you disclose it, then you put your own information into the record. You potentially are going to be found to be biased there. If you don't disclose it, then you violated the ex parte contacts. So just don't do it. Don't do your own research. And yeah, that's a great question too. Sometimes when you have a really contentious land use issue, I've seen situations where planning commissioners, city councilors will get 100+ emails about that application. And the best thing there is just don't read them. Don't read them. And then you can say, a bunch of emails came in, I didn't read them. If they want those statements to be put into the record, they can do that.
Come here and
submit them.
stand and
Right.
put it in. the
But if they're just emailing you individually, that's not the process to get those into the record. Could move on to conflicts of interest. This stems from Oregon government ethics law, which is applicable to all of you as planning commissioners, but comes up a lot in the land use application, particularly quasi-judicial application context. And there can be two types of conflicts of interest. Oregon government ethics law, this surprises some people, is only really concerned with economic conflicts of interest. And so what an actual conflict of interest is when the decision that you make will result in a private, this is pecuniary, but that's financial benefit or detriment to you or to your relatives' household or businesses, and a potential conflict of interest is when your decision may result in that type of benefit or detriment to your relatives, household, businesses, or yourself. Regardless of whether it's an actual or potential conflict of interest, you have to disclose it. And if it's an actual conflict of interest, you have to recuse yourself. I have a recommendation on here to leave the room. That applies anytime you're recusing yourself, whether it's bias or conflict of interest. Just completely leave the room. And there are a few reasons for that. One is that there can be situations where just your presence in the room can be construed as trying to influence the decision. It also can be very difficult during a land use process to avoid any sort of nonverbal communication, thumbs up, clapping, rolling your eyes, that sort of thing. And all those are things you really want to avoid when there's a conflict of interest situation. And so just completely extricate yourself from the situation is going to be the best to protect the interest of the city in terms of an appeal and protect yourself in terms of a conflict of interest allegation. Because as I note here in one of the last bullet points here, in addition to causing appeal issues for the city, because government ethics obligations are personal to you, a violation can result in personal liability for public officials, which includes fines from the Oregon Government Ethics Commission. And if you realize some financial benefit as a result, up to double that financial benefit can be assessed against you. And so I recommend caution whenever there's any possibility of a conflict of interest situation to avoid that. And unfortunately, because it is a personal liability risk, my ability to advise you, because I am an attorney for the city, not for you individually, is limited. And the fortunate side of that is that the Government Ethics Commission has an email address and a phone hotline that is for the sole purpose of answering questions and providing guidance when you have a situation like that. So if you're ever in doubt, call OGEC, explain the situation. They'll tell you whether you should recuse yourself or not. Abide by their recommendation. That's my advice.
Can you flesh out what it means to be a relative a little bit further? Like what the courts have decided on that?
Yeah, there's a definition of relative. I'm not going to be able to list all of that off the top of my head for you because it varies from law to law. I believe I just
be tied to that person.
I believe I just it was for some other client and it was one of the other attorneys in our office. I can't remember exactly the way that the quirk cuts, but I believe it's like your sister-in-law, if it's your sibling's spouse, is a relative, but your sister-in-law, if it's your spouse's sister, doesn't count, something like that. Like they clearly a oversight when they were drafting the definition of relative, but there's a definition in the statutes for exactly how which relatives count. But again, I would err on the side of caution. If there's anybody who is, because it also includes household, right?
Yeah.
So anybody that is like a relative to you, I would encourage you to consider that at least a potential conflict of interest. Call OGEC.
And then one of the things, sorry, Josh, I'm just asking some things that I remember coming up in previous conversations that we've done this with David or Chris. I do remember in one of those, like legal trainings, there was some discussion about what qualifies as a business and what doesn't. And I know David always brought up the example of if you have stock in something,
Right.
if you could just kind of explain that a little bit.
Yeah, and again, there's a long list in the statute of the different types of do and do not qualify. But what's obviously going to qualify is if you're the owner of a business. Another thing that qualifies, if you have to fill out the statement of economic interest form, which is based on where your income comes from, that qualifies as a business. If you are a volunteer at a nonprofit or an unpaid board member at a nonprofit, it doesn't count. And just owning stock in a company also doesn't count.
Mhm. This one is probably the most misunderstood by the public. Because everything is a conflict of interest, you have a conflict of interest because that's your neighbor. applying for that land use and, you know, because I've talked to a lot of people and had the sound that it's deals with money. And because we use that phrase in the general populace over a myriad of things. And when you get here, it's really narrow.
That's exactly right. You know, the applicant could be your best friend since kindergarten, right? And as long as you don't have any actual financial interest in that, that is not a legal conflict of interest. Now, whether that is a ethical conflict of interest is up to you. But legally speaking, no economic interest involved, no conflict of interest.
What about employee?
Your own employee?
Or you're an employee of something that's in front of you?
Right. So yeah, if your source of
They
income
pay
comes
your
from the
salary.
applicant,
Yeah.
then that is a business with which you're associated, and that's a conflict of interest. Yeah.
I know it doesn't happen that much on appointed boards, but I, in the past, have seen councils. One in particular in Lake Oswego, where they had so many people on the city council who had vested interests in so many different. It was hard to come up with a quorum of people who weren't going to benefit either financially or whatever from actions that came before them. They usually got around it, but yeah, I think it'd be the same as if you had a planning commission where you had a couple contractors and real estate brokers and people who would have a hard time in land use action, not having some sort of conflict come up.
Yes. Now there are a few exceptions to address those situations that are have to be very narrowly and carefully applied. But there is a provision in the state law for if conflict of interest means that you don't have enough people to even vote, then you're allowed to vote.
Declare
anyway.
your bias.
Right. And there's also this concept of it will provide an economic benefit or detriment to you personally or your relatives' household businesses, but it in the same way that it applies to a very broad class of people.
Right.
So, for example, you know, if you're going to, I guess a great example would be for like a city councilor who is like enacting a new tax, right? That's going to affect the entire city. That is going to be to their financial benefit or detriment, but it applies to the entire city. And so the Oregon Government Ethics Commission has the ability to declare something as something that falls into a broad class,
Right.
and then it allows you to be able to vote still.
Cool.
There are a couple other government ethics laws that I want to touch on briefly. Prohibition on use of position or office, which prohibits public officials from using or attempting to use their position to obtain a financial benefit if that benefit would not be available except for the fact of that position being held by the public official. So an example of that is using public resources to conduct your private business. And it could be as simple as using the city printer to print out for yourself, for your personal use or for your personal business, or using a city computer. That doesn't come up very often for planning commissioners, it comes up more often for city councilors or employees, but that's an important one to keep in mind. In most cases for you all, that would probably overlap with conflict of interest. And then gifts can be a difficult one. A gift is defined as anything of economic value, which can include discounts or forgiveness of debt that is not offered to the general public. And the question you have to ask when a gift is involved is whether the person who's giving you that gift has a legislative or administrative interest in your decisions or votes, which in turn refers to having an economic interest that's distinct from the general public in your decisions or votes. So an obvious example would be, applicant for a subdivision that's going to be coming to you all, sends you all gift baskets in advance, right? That person clearly has a legislative or administrative interest in your decisions. And so if that applies, then the maximum amount of gift that they can give you is $50 per calendar year. So they can send you those gift baskets a week before your hearing. It doesn't look very good, but they can do it as long as they're valued at less than $50.
That's not a great gift basket anyway.
Or, a bouquet of flowers or something, right? But they can't exceed that $50 value. And if they don't have that type of interest in any of your decisions, then you can, you know, your spouse is still free to give you as much gifts as they want to give you.
I was kind of wondering, being on a state commission and on a special district board, in both cases, we had to take the OGEC training, but cities don't do that.
So city officials are now mandated to take the OGEC training. That's new starting this year. The state law, in my opinion, was a little ambiguous, but OGEC's guidance is that it does not apply to planning commissioners and other boards and commission members unless that, so the way the statute is set up is if you're on the governing body of any public body that has it's $1 million, I think it's $1 million or more in budget, then you are subject to the OGEC training.
You don't have that.
There's some boards and commissions in some communities that maybe do, right? Like maybe.
Christina's
but-
gonna have to do that,
What's that?
our incoming city councilor.
City councilors will,
Yeah.
city councilors absolutely will have to do that.
Yeah.
What was ambiguous in the statute was whether that $1 million referred to the city or to your specific board or commission. OGC has interpreted it to be your specific board or commission. So
Okay.
until such time as city council gives budget authority to the planning commission to spend $1 million a year, you all are exempt from that training. That being said,
We're cool.
it's a good training. It's important information. The trainings are free. And you can sign up for live trainings from OGEC, or our firm is going to be putting on a live training next month that will also be recorded and viewable for free on our website. So if at some point you want to sit down for a couple hours, I think it'll probably be about a 2-hour-ish training, and learn everything there is to know about ethics law, which applies to you, so it's good information to know. Consider doing that.
I think the one thing they do, that the commissioners do have to do still is fill out that you fill out something every
Statement of
January.
Yeah.
economic interest.
Yeah, there it is.
Yeah, you still have to do that.
So I don't know if everybody's, has anybody got an email about that yet?
I have not, but
It's between March 15th and April 15th.
Yeah,
Oh, it is, okay.
It
I
opened
didn't-
up March 15th.
Yeah, I think
It's
We get a
relatively quick.
warning email.
Got it.
Jeff normally sends out the reminder too, I think.
Okay.
So when's the training gonna be?
So OGC has ongoing trainings that you can sign up for. I think they have one next week and the week after, then they may already be booked up. Our training will be mid-late February. We haven't announced a date yet, but it'll be posted on our website and we'll send an email about it when it is posted. And we have a YouTube channel that you can go to and watch it anytime afterwards. So you don't have to try to, block that date in your calendar. Okay, if there are any other questions on that, I'm going to move on to public meetings law, which, the important thing here is, as I hope, hopefully all of you know, planning commission, city council, all boards and commissions are subject to Oregon public meetings law requirements. In a nutshell, that means that all meetings have to be publicly noticed and open to the public. It applies to any meeting where decisions or deliberations on matters of official business occur. And it includes electronic communications. So kind of and I'll dive into serial meetings here in just a minute, but I guess the important thing, practical level takeaway for you all is, if you are in a meeting setting like this, you really don't have to be worried about public meetings law issues. Staff has already taken care of the noticing requirements. It's open to the public. Whenever you're doing anything in this setting, you are complying with public meetings law. What you have to be concerned about is anything outside of this setting, whether it's social media or it's email or it's getting together for coffee, that sort of thing. Anytime that you're discussing anything relating to public business in those settings, that's when you should start setting up little red flags in your mind. And what you can't do is have a quorum, a majority of the planning commission involved in those conversations outside of this setting. And that means a quorum all gathered together at the same time in the same place. That means a quorum in an email list or a text chat group or whatever. It means a quorum of people who are reading and responding to the same Facebook post. And it includes this serial meeting concept. Even when a quorum isn't contemporaneously involved, when a quorum is involved over the course of the communication. So whether it's through an intermediary or email or social media. So for example, if 3 of you get together and talk about something, that's fine. That's not a quorum. But then one of the people from those 3 then meets up with a couple other planning commissioners and is relaying information about what happened in that previous conversation to those others. Then you've constituted a quorum over the course of that communication. Or the same thing if it's not one of the other commissioners, if it's Kelly that is acting as the intermediary, then you violated public meetings law. And so you should avoid those situations. This is also part of the OGEC training, or our training that we're going to be doing next month. And so would encourage you to
Group emails.
Yeah.
Yeah, that's, and it wasn't a big deal because we weren't discussing a pending land use action, but when I sent the email, I think it was last week sometime,
6.
just saying, hey, like, we could just send it just to Patrick, Darren and I, and that was for this very reason. It was just to avoid that from occurring.
Cleaner.
Exactly. And I wasn't really that concerned about last week because it's not like there was a pending
Just
land use
training.
action, but it was
Just
just trying to get everybody on that,
Right.
what do you call it?
Get them on their way.
Yeah, get used to not doing that.
Yeah, right.
Essentially.
Avoid reply all.
Yeah.
Lie.
Exactly.
Yeah, and I apologize. I should have made that clear when I sent that out.
Any questions on that before I move on? So I'm going to move into a little bit about hearing requirements, and these are requirements for quasi judicial hearings. State law requires particular notice to be sent out. Typically staff will provide a script that the chair has generally the privilege of reading to open the hearing, which is going to address some other legal requirements such as the raise it or waive it requirement or identifying the criteria that are applicable to the decision. At the initial evidentiary hearing, that's the term that the statute uses, which is the first hearing where evidence is taken. Anyone can request time to present additional argument or evidence, and it has to be granted. And it can be granted either by having a open record period for people to submit additional written arguments and evidence, or you can continue the hearing to a future date, at which point you'll take additional argument and evidence. But you have to do that once at that initial evidentiary hearing, give people more time if they want it. And then the applicant will have, under state law, 7 days after the record closes to submit final written argument. But applicants can and very frequently do waive that. So you often see decisions made without that formal 7-day period. Talking a little bit more about hearings issues here, the presiding officer which is the chair, has the inherent authority to maintain order and decorum in a meeting, which includes the ability to establish reasonable rules for the conduct of meetings, such as the order and length of public testimony, although that is sometimes specified by ordinance or other rules. But in the absence of that, the chair can say, everyone's going to get 5 minutes, or everyone's going to get 3 minutes, or whatever the time period may be. And just generally maintaining the orderly procession of the meeting. Where that gets difficult is when there's a disturbance at the meeting. And so I have a few suggestions here. The recommended process for if somebody is causing a disturbance is to first provide a warning saying, you're disrupting the meeting. I need you to stop doing that. If they do it again, you say, you're disrupting the meeting again. I'm going to ask you now to leave the meeting because you've disrupted it twice. And if they don't leave, then legally they can be treated as a trespasser and removed from the meeting by law enforcement if necessary. And my practical tip here is don't try to do that while you're still in your open meeting. It can get really ugly really fast. They'll use the opportunity for grandstanding, that sort of thing. Call a recess. Call in somebody from law enforcement if necessary. to come and escort that person out of the building.
I had a quick question on this actually, for my own education, since we're talking about it.
Yeah.
We have not luckily had to deal with it yet, at least on planning commission. What if we get a Zoom bomber? Can we
Zoom-
legally kick them off the meeting?
Zoom bombing could be a whole nother presentation. And in
Sorry.
fact, at a recent city attorney's conference, we did have an entire hour-long presentation on Zoom bombing. For those of you who don't know, it's essentially where somebody is using Zoom or Teams or whatever your system is for people participating remotely to cause disruptions and just unbecoming conduct, basically. We've seen a number of instances where they start spewing racial or religious bigotry or whatever during the course of public comment period. So the important distinction there is whether they are disrupting the meeting, in which case these guidelines would apply, or whether they are just engaged in, really despicable speech, but still protected free speech, right? So if they are actually disrupting the meeting, these same concepts would apply, but generally you can just, instead of having to go through all these steps, you can use the controls within your application to, mute them or require them to raise their hand or whatever to prevent an actual disruption from being able to conduct your business. If they are, it's their allocated time period and they're just engaged in speech that you find deplorable, that is a more complicated issue. As you may be aware, as I'm sure you are aware, we have freedom of speech protections under the U.S. Constitution. We also have them under the Oregon Constitution, which the courts have repeatedly held are even more protective of speech than the U.S. Constitution. And so anytime you are responding to and preventing somebody from speaking based on the content of their speech with very limited exceptions, that is risky territory in terms of freedom of speech protections. And so a number of, the other challenge is that you can during the course of a public hearing, limit what people are speaking about to the application and criteria. But some of these Zoom bombers have gotten very clever at tying it back to the criteria. And so my general advice in those situations is, if that starts happening, first, take a recess. So you can, cooler heads can prevail. You can consult with staff, consult with the city attorney about how to deal with this particular situation. Often what we end up recommending is this doesn't work for a public hearing, but for public comment period at least, move it to the end of the meeting and then tell people in the audience that we're going to go back to the public comment period. You don't have to stay here. Staff even, you don't have to stay here. You're free to go. So people don't have to be exposed to it as much.
And they don't have an audience, so they're less.
And they're less likely to do it because they don't have an audience. Also, and it seems like a minor thing, but it can be helpful. Controlling the volume in the room, right? If it is like the loud like voice of God in the room spewing hatred, that can be really impactful, more so than if it is just more of a murmur in the room. You can't mute them, but you can reduce the impact of what they're saying through those means. And frankly, some cities have chosen to accept the risk of the freedom of speech violation in certain circumstances when it's really egregious conduct and shut people down.
So we're talking difference between hate speech, threats, or just profanity, or all of the above.
Exactly, right. So, threats, true threats, which is a high bar under the law.
Right.
Or, like the classic shouting fire
If
in
you do
the
this, I'm
crowded
gonna
theater.
kill you.
Right.
Yeah.
Those things, are not protected speech under the Constitution.
Okay.
These are not usually those things. These are ideas that most people find reprehensible but are protected speech.
Okay.
The other thing that you can do is you can't stop somebody from exercising their free speech rights. I think there's one of the forefathers who said the cure for, you're not gonna get the quote exactly right, but like the cure for reprehensible speech is more speech, right? You can respond to and condemn what was just what just happened. So you can let them say their piece, and then you can say, you know, City of Sandy, you know, or the planning
Okay.
commission, or whatever, we don't tolerate that
Denigration
sort
of
of
a
thing. We don't
person.
agree with
Yeah.
that. That sort of thing.
And sorry, just one more thing on that, because we haven't really had a formal training on this. And I've been
Has it
very-
ever happened?
It hasn't yet.
Not here.
It has happened to my spouse at her work, for Zoom meetings several times. What if they start showing offensive, or what some people would label as offensive images? Does that count as free speech?
So the line between what images and are not protected is also can be fraught with peril. My recommendation is to not allow them to share images for that reason. Right?
Yeah, there's
So-
actually a couple, I'll just bring it up, I'm not gonna make a big deal of it, but there's some clever Zoom bombers that have actually figured out that you don't have to do share screen. You just have to, because when we let them join, a lot of times we can visually see them. They can just show what's in the background, yeah.
Yeah, there was this is before Zoom bombing, and I think it was a different issue, but there was a person who was going around to public meetings naked on Zoom. I think your best bet is to turn off video
Show up in
public-
person if you want.
across the
naked.
board for all commenters. Just
Yeah.
we're not discriminating based on the content of your speech. We just don't allow public commenters to have video.
Fair enough.
So this might be a dumb question, but how do you trespass somebody from a public place?
Yeah, so people are allowed to be, a public place, it depends on what you mean by public place. So a public street, everyone has the right to be, generally speaking, at all times, as long as they're using it for, obstructing traffic, that sort of thing. City Hall is, and other places like that are somewhere in between that and private property. Where you
Business
can.
is conducted.
Right, exactly. So in that respect, in the respect of trespassing, it is more similar to a private property. In that if somebody is asked to leave by a person with authority to ask them to leave, and they refuse to do so, then they are trespassed. Now, whether that is for in that moment, you can, in order to be able to prohibit somebody from like coming to City Hall entirely in the future is a whole different
Much
ball of wax.
higher criteria.
Right. But to get them out of that individual meeting setting at that time, that's all you have to do.
And it's similar to public schools, which are.
Right. That's good. That's a good example. Yeah. Okay, so moving on to criteria and findings. So important things to keep in mind here when you're making decisions. Criteria. Your approval or denial must be based on the standards and criteria that have been adopted by ordinance. And your decision, and staff generally handles the second part here, but your decision must be accompanied by a statement that explains the relevant criteria, the facts that were relied upon, and a justification for the decision based on the criteria. So it's essentially taking what the rules are, taking what the facts are in this case, applying the rules to the facts and explaining how that leads to the result. Your decision also has to be based on not just evidence in the record, but substantial evidence in the record. And you have to resolve conflicts of the evidence. So, for example, if you had a situation where the applicant has a traffic study that says the traffic impacts are going to be X, and you have a really organized set of opponents who get their own traffic study and say the traffic impacts are going to be Y, you have to choose which one and explain why you've chosen this traffic study over this traffic study. You have to weigh them and resolve that conflict in the evidence.
Wouldn't Kelly do that for us prior to our decision?
So generally speaking, yes, that's why I said generally staff handles this for you. Now, staff is going to produce findings in a staff report based on their recommendation. If you reach a different conclusion than what staff has recommended. So staff has recommended approval and you decide to deny or vice versa. Or you want to approve with different conditions than what staff recommended. We're going to need to develop findings to support that change
Back
in
it up.
decision,
Yeah.
right? And
Yeah.
so it's really helpful in order to be able to develop those findings for you to be addressing this during the course of your deliberations. What is the weighing of evidence that you're doing? What is the application of the rules to the facts that you're doing? What is the basis for your decision?
Now, if there are a lot of those things where we're going against what our expert staff person says we should do, are those a lot of times, then we carry over the decision to the next meeting so that he can come back with supporting documentation for our going against his recommendation?
So different communities do
Unless
this.
there are
Yeah.
time constraints, I know.
Different communities do this differently and time constraints can play into it. Generally speaking, if I'm just answering in the most general sense possible, if you're reaching a different conclusion than what the staff report recommended, and therefore there aren't written findings to support that decision, if at all possible, yes, you should be delaying to allow, and it doesn't even have to be delaying your decision. You can tentatively decide
Right.
subject to findings and
Subject
have
to
have
findings.
staff bring back findings based on your
Or
deliberations.
instruct staff to bring back findings to support the decision we're making tonight.
Right, exactly.
Yeah.
And in the case of like a traffic study, I've actually, in my 20 years of doing this, I've actually never had like a group of citizens get a traffic consultant. I have had a group of citizens get another like arborist involved, and I've also had where like one of the citizens in that neighborhood is like a PE. So they'll come and testify and give their expert advice. In those situations, typically, that's one of the reasons why we have the stormwater reports and the engineering documents, if there's like retaining walls, all reviewed by RPE. And then that's another reason why if they submit a transportation engineer or a transportation study, then what we do is we take that and send it off to our third party transportation engineer, DKS. And so they basically fact check it for us.
And there's no gotchas at the meeting where he gets up to
Exactly.
do his testimony and says, here, I have this traffic
Exactly.
study. I'm
And
handing
we
it to
would-
you right now.
And that's right. And we
Yeah.
would say, we already had this traffic study from the applicant reviewed by an independent third party, and here's the comments that they get. So that's what we would typically do.
Oh, great.
To move on to talk a little bit about appeals. First, we'll start out with local appeals. So as you probably are aware, applications are generally going to be divided into categories in your code, such as type 1 and type 2, which will define who the initial decision maker is, and then also who the appeals go to. And when there is an appeal can either be de novo or on the record. De novo meaning it's a completely new hearing. They'll look at what you did before, but they're going to conduct the whole process from the beginning and reach their own decision. Or an on the record appeal, which means the appeals body does not take in any new evidence. They just look at the evidence that you brought into the record and then reach their own decision based on that evidence. After that appeal, which in your case is generally going to be to city council, further appeals would be to the Land Use Board of Appeals, and then from there on to the Oregon Court of Appeals and so forth. And this is the part that I alluded to earlier. To keep in mind that when a decision is appealed to LUBA, LUBA can affirm, reverse, or remand. And if they remand, which they often do, as their sometimes I think their favorite outcome, you may be making a new decision again on that same application again in the future. And so you want to think about that in terms of bias and ex parte contacts in terms of your conduct after the decision is made. So continuing to avoid ex parte contacts, at least until you know there's not going to be an appeal, the appeal period is expired, or if there is an appeal, it's resolved and then that appeal period has expired, in terms of ex parte contacts, but also in terms of comments that you make subsequent to it. You know, I've seen situations where, and something gets appealed to the city council and a planning commissioner wants to go and testify at city council, either for or against that application. A lot of codes will allow, for city council even to remand a decision back to the planning commission. So,
It's happened.
so
Yeah, we
just
do.
don't.
We actually had a planning commission.
Continue
that did
to-
that.
Continue to conduct yourself in the same way until the application is completely fine.
Is it your experience that when there is an appeal at the hearing where you make your decision based on the attitude and response of the applicant who is either denied or the people who wanted it denied and it was approved, can you usually tell if they're gonna appeal it based on their response? Like if they're leaving the room going, I'm taking this to a higher court, no. Short of that, I mean, you can see when they're really upset.
There's a significant number of, I would say the majority of the time, yes, you can tell. But there are also enough times where we're
Blindsides,
surprised.
Yeah,
I mean, I had one just recently for a different client where we thought everything was resolved. There was very little opposition. The decision was approved. But then the applicant decided they didn't like one of the conditions in the decision, so they appealed their own approval to the city council to try to get
on that one condition
one
there.
condition removed. Yeah.
We've had that too.
Yeah.
I mean, in my tenure here, just so the new commissioners and all the commission knows, I've actually never seen an appeal done on the record. Do you recall one ever being done on the record? They've all been de novo since I've been here
Yeah.
at least.
They're boring when they're on the record.
Okay, I've never actually
Doing it
dealt
all
with
over.
one. Okay, I've never dealt with one, Sandy.
No.
You may all have heard at this point about the 120-day rule, so I just want to talk about that a little bit. This is the rule in state law that the city has to make a final decision, including a resolution of all local appeals, within 120 days after the application is deemed complete. Failure to meet that deadline has two major consequences. One of which doesn't come up very often, but can. So the first one is that it requires the city to refund at least 50% of the fees or deposits or the unexpended portion of the fees or deposits, whichever is greater. And the second one is that it allows the applicant to file a writ of mandamus in circuit court, where the judge will then will approve the application unless the city can show that it would violate the code. That second one doesn't happen very often because our court system takes a long time to resolve cases. And oftentimes if the 120 days is violated by just a small period of time, the applicant's going to say, I'm better off waiting 2 weeks to just get a decision from the city council rather than try and take this to court and take several months to get a result. That 120-day time period can be extended in writing by up to 245 additional days beyond the 120 days, or up to 335 additional days if the parties enter mediation. My practical recommendation here is to have blank forms available at a meeting to extend the 120 days, so that if the applicant says, I'm going to extend the 120 days, you can get in writing right then before you agree to a continuance, because I've had them have changed of heart afterwards, after agreeing to something orally in a meeting. So
and that's really the only timeline you run against where you can't carry it over to another meeting. Is if by carrying it over to the next meeting, you're gonna go beyond the 120-day rule.
Yeah, and at the planning commission level, you have to keep in mind that there's almost always an
City
appeal to city council. So you gotta, if you're
That
gonna
falls
extend this
within that
one
same-
and then the appeal
Yeah.
and then them, you gotta give quite a buffer for that city council appeal, because city council may also need more than one meeting to consider.
Correct.
And Patrick and I will always be tracking that, and if we ever did run up against something where we're concerned, we would let you all know.
Great.
The fixed goalpost rule is one that we've had in Oregon for a very long time, which is that the applicant essentially locks in the rules that are in place at the time that they submit their application. If the city subsequently, you submit an application for some sort of development, the city subsequently enacts new legislation that changes the rules for that type of application, they still get to proceed under the old rules that were in place at that time. The city doesn't get to move the goalposts. Just this last legislative session, HB 4063 modified that rule in the context of housing development specifically, to allow at the applicant's discretion them to opt into new rules that were enacted after they submitted their application, rather than having to withdraw and then resubmit an application to get access to those new rules. A lot of cities were already allowing folks to do that. But for what it's worth, that is now formalized in state law. And if an applicant does that, that completeness review and the 120-day period all start over. You get to, it's essentially as if they submitted a new application.
We had a situation in town where we adopted a dark skies ordinance that some businesses had already started to develop, the Fred Meyers in particular. They didn't have to do it, but they did comply with it, even though they were already in the process. But they wouldn't have had to.
That's right. They can
Comply with
choose
the
to
dark
voluntarily
skies,
comply,
yeah.
right? Talk a little bit about clear and objective requirements, and we're getting close to the end here, I think. This is a requirement under state law that all standards, conditions, and procedures regulating the development of housing must be clear and objective. And if they aren't clear and objective, they cannot be applied to an application. This is one of those things, you know, you just recently went through a clear and objective code audit, so you're generally, most of you I think are familiar with this concept, but it sounds really simple in practice and it is incredibly difficult, if not impossible in reality. And this is one of those situations, I encounter this a lot with local government law, where I really wish that the state legislature would try to apply the rules that applies to cities to itself for a while and realize how difficult they are, because they don't write clear and objective statutes, not even land use statutes, related to housing, because it's very difficult to do. And they might then change their mind about applying those to cities, but this is the law that we have for now. And the law does allow for cities to provide an alternative, optional, discretionary path that applicants can choose to follow as long as they still have access to that clear and objective path to develop. And, you know, I think Sandy is frankly pretty far ahead of the curve as far as the average city in Oregon in terms of having clear and objective code. You're in very good shape there. I don't know that any city has 100% clear and objective code related to housing, but Sandy has got to be one of the
Is it
closest.
sometimes in the eye of the beholder? Whether
Oh.
it's clear and objective?
Well, it's in the eye of Luba and the court of
Yeah.
appeal and
Yeah,
Supreme Court.
yeah.
But yeah, yes. I mean, you would think that clear and objective, whether something's clear and objective or not, would be clear and objective, but it's
Yeah.
Yeah, it took us on one, so we did this project for a couple of years and Josh helped a lot with it with our consultant MIG, who I mentioned earlier. And I think, I just remember one meeting we had with them, it took, you know, Josh, myself and two consultants, I think a half an hour on one definition. Because it was just so complex and we kept running into issues. So it is very challenging.
Yeah, and what's really challenging is oftentimes the policy goal doesn't lend itself to a clear and objective, like numerical, mathematical type standard. And so trying to figure out a way to approach that policy goal from a different angle can be very difficult.
Split the baby.
Moving on to constitutional issues. The most important constitutional issue for you all as planning commissioners is the concept of a taking, which is a government appropriation of private property. And under both the federal and state constitutions, the government is allowed to take private property, but must provide just compensation for that property. And that can be, you know, the most common example that we think of is, you know, the state wants to build a highway through a bunch of people's homes. They have to buy the homes at fair market value, right? That's the quintessential example. It can also be the result of regulations that limit the use of property, but most commonly, and what you're going to encounter is it being the result of exactions in a land use context, which is conditions of approval that require the transfer of private property, which can be road dedications, and it can be where the property is actual physical real property, or it can be, for example, construction of improvements where the private property is money. In order to be lawful, exactions must meet two requirements, which come from the companion cases Nolan and Dolan of the Supreme Court. First is nexus, which is there has to be a relationship between the exaction and the underlying regulation of the property. And the second is where we usually get hung up is rough proportionality, which is the exaction has to be related both in nature and extent to the impact of the proposed development. So, for example, the road dedication and road improvements that you could require of a 200-unit subdivision, you could not require of a single family home on a single lot, right? Because the impacts on the traffic system of that massive subdivision are enough to justify a lot more exactions than the impacts of one home. And so you have to make sure, and where that line is, the term rough proportionality, as that may suggest to you, courts have said it is not a mathematical certainty. It is kind of a, you know it when you see it situation. And so frankly, the way it works is it ends up being a negotiation process, just like, you know, what is a used car worth? Well, it's worth whatever the dealer and the seller and the buyer land on as far as the price.
Isn't it sometimes for like an improvement? If not you, who? Like if you want to develop your land and there's a frontage on a street. Who is it more fair to make improve that frontage? You who want to develop the property or anybody else?
Yeah, I mean, I think that can factor into nexus, right? Like
Right.
there has to, that you are causing traffic impacts, therefore you should be contributing to the traffic
Right.
impacts.
And our city requires sidewalks, so.
Right. Now, where that can get tricky is, you are developing this property. We would really like you to do all of these road improvements, and we don't feel like it would be fair to require the taxpayers to pay for them. But really, some of those improvements are beyond the scope of the impacts being caused by that
Correct.
particular development.
Yeah.
As much as we don't want it to, the taxpayers are going to have to pay for that.
Off-site improvements can be tricky as well.
Yes.
So if you want something to be improved, but it's not
Necessary
abutting
to
to
the,
the development, that can be a tricky thing to get. And typically as staff, we won't recommend those.
It can be harder to get to both nexus and proportionality in those situations. That's true.
Does that apply to like reimbursement districts? Like if you have somebody you're pulling, because I mean, I've done reimbursement districts, so I don't know, I don't think it does, but maybe for their benefit, like, so someone that's building out here, they have to put in a lot of sanitary sewer or water pipe to get there, which is a lot of money, can cost a lot of money, but they can enter into a reimbursement district where the people that develop in between then pay them back.
Right. Yes. So as part of that, you've done some of these before, that as part of that reimbursement district process, there's an analysis for all the properties that come in later that are going to have to contribute to reimburse the person who upfronted that
like the
cost.
share.
There's analysis of what benefit they're receiving and what their fair share is. And that's so that's how you make sure there's proportionality there. For the person who's making the upfront investment, they're running a risk that those other properties don't develop and they don't get reimbursed, but because they're doing it voluntarily, the government's not requiring them to do it. That's how you avoid a taking issue there. All right, this is my last slide before we get to the questions and additional resources slide. And this is just an update on one key piece of recent legislation to flag it for you. But I think this is the most impactful kind of, I don't think it's even going too far to say this is a sea change in land use law. Went into effect January 1st from the 2024 legislative session. Legislation that creates a process for mandatory adjustments, which is essentially variances that cities are required to approve for housing developments. Cities will be required under this are now required under the statute to allow up to 10 adjustments to certain specified land use regulations for development of housing. And there's a very long list in the statute of the types that qualify, and they range from everything from side and rear yard setbacks, lot sizes, to parking minimums, facade materials, colors, roof forms, balconies and porch requirements, all of that. You're required to allow developers up to 10 adjustments in those categories. Unfortunately, it is unclear how you count to 10 under the statute. And some of those categories are a little unclear too. And sometimes it's unclear whether an adjustment under a particular category would be one or two adjustments, or what the scope of those particular adjustment categories are. But just to put on your radar that when you get
I
housing
think there may have been
applications
some
moving forward,
lobbying involved in this legislative act. by
There
maybe
was,
some people who had a vested interest in getting those 10 adjustments.
this was a heavily negotiated and this was part of the governor's must-pass legislation last session.
So,
And,
so,
right,
oh, sorry.
Go ahead.
So two good things to keep in mind is one, there is a process for local jurisdictions to submit an exemption to portions of Senate Bill 1537, and currently staff were working on submitting that exemption request. So how it's going to work is we submit the exemption request. It's a pretty lengthy thing we have to submit, but we're currently working on it. And then basically, this bill gets paused locally for our jurisdiction until the LCD has approved or denied our exemption request. So that's one positive thing. We are working on that. The second positive thing is, as Josh pointed out, there's a lot of unknowns around this. However, because of the moratorium on development currently, I'm hopeful that this will get kind of worked through and the kinks will get worked out through other jurisdictions prior to it being applied in Sandy for a big, like a large housing subdivision or apartment complex. So I am hopeful that it will have somewhat of a less impact in Sandy than it does in some other jurisdictions this year.
I'm thinking more of commercial and Sandy style exemptions, saying that they don't have to comply with Sandy style
This is only for residential.
rocks. This is only residential.
Yeah,
And
Okay,
is
yeah,
this,
which is the saving thing that.
yeah.
is this 10 adjustments per lot, per structure, per
Development?
application?
that's one of the fun parts about
Excellent.
lack of clarity about counting to 10.
Excellent.
And the lack of clear and objective written language in the legislative materials.
It wasn't written by a planning director.
I don't know who it's written by.
Legislative council
Okay,
Yeah.
there you go.
and lobbyists, I'm sure, too, as well.
Yeah.
And does this have to be for like new applications? It can't be for something that's already existing?
Where they can come in and change it.
So it would be anytime that you need land use approval related to a housing development, right? So, I mean, it could apply, you know, if you have, if there's something that somebody wants to make a change to something that's existing.
requires an
requires land use
application.
approval. Right.
And is there, I'm sorry, is there a time limit? Can they go, we want to do these two and then come back 6 months later when they adjusted that, add 4 more? Is it a total of 10 or is it 10 submitted all
They
at once? Or can they just keep tweaking things as they go?
get up to
And then go
10, they get up to 10 adjustments per land use decision. But if they got a land use decision with 10 adjustments and then resubmitted that land use application, they could choose 10 different adjustments, but they don't get those 10 that they previously got. They'd be getting a new decision and only get 10.
It's very confusing.
It's like monopoly.
So if you're saying, you have a development, a subdivision with 50 lots. And the developer on all 50 lots wants a 10% reduction in the rear yard. Is that 50 adjustments or is that one because it's applied, that's your one land use approval?
That is exactly one of the questions.
Okay.
I mean,
I would think that'd be one.
I will throw out there, I mean, I don't think it's clear from the statute, but I think the intent is clear that would be one.
Yeah, for reading all the documentation, I would think, yeah, exactly. I think that the intent's one.
It'll be interesting to see it, how it works out in actual land use decisions.
So the interesting part too is we have to approve them. But we can still process the adjust, so they still have to submit a subdivision with 10 adjustment and variance requests, pay the fee,
Up front.
and then but we'd have to approve it.
So like, for instance, on Holt Homes there. Because they face 2 right of ways, we have. 5 to 6. Design elements for the front elevation, but then facing. Highway 26, all of those need at least 3. If they were to eliminate, they could eliminate one of those. And that's one adjustment. Am I looking at this as one adjustment or like 1 out of 3 is like 33% reduction?
Right.
Yeah, I think in Sandy, it will be a little bit less of a burden. And the reason why is because at the subdivision level, they'll be able to request the 10 or at the apartment level. But then individual lots they go through a design review, but it's not real, it's not a land use design review. It just goes through design review through the building permit. So I think it'd be very hard for them to get 10 additional adjustments or variances because they're not even submitting a land use application for that individual house. if
The
that makes
part
sense.
where it's gonna be hard and you're gonna get blowback from adjoining properties is, I think, in the setbacks thing where your property as it exists now has a certain setback. But now that guy coming up and building something behind you only has to be set back 5 feet instead of 20, to where you end up having neighbors encroach on existing properties because you're not requiring the setback that was required when they built their property.
Well,
So
I
a
mean,
fairness issue.
yeah, but I mean, do keep in mind if you have a 15-foot setback, that's only being reduced by a maximum of 1.5 feet, right?
Yeah, there's a maximum of 10% on setback adjustments.
Yeah.
So I mean, we're not going from 15 to 5, we're going.
Right.
from-
Some of them have those limits,
Lot sizes.
numerical percentage limits, and others don't.
And setback.
So arguably, in some of those, that means that arguably, the requirement cannot apply at all. Right?
Right.
They could get completely exempted.
Good luck.
So
Good
a
luck,
few
Kelly.
additional resources here. Oregon Land Use Training.info is a little dated, but still very good training website. If you want to go through another land use training process. There's a document called Introductory Guide for Land Use Planning for Small Cities and Counties in Oregon, which is a bit dated, but still valuable. And then the OGEC puts out a guide for public officials that address conflicts of interest and other ethics issues, which is very helpful. Has illustrations and examples. Highly recommend that. You can Google either of those second ones and find the link. And then I also included, because I encouraged you to contact OGEC if you have ethics questions, their phone number and email address and their office hours there. And are there any other questions?
No, they're very helpful.
I just want to pause for a second just to make sure there's nothing online. All right. Thanks, Josh.
Yeah, my pleasure.
Thank you.
Yeah, thank you very much. Appreciate it. You guys want to take just a couple minute bathroom break or?
Okey-dokey.
Should we wait for Patrick or?
I think you can start.
Okay. All right, welcome back, everyone. We'll go ahead and get started, moving to our next item on the agenda, which is our 2025-2027 Planning Commission goals discussion. As usual, Kelly, you want to kick us off?
Thank you, Chair. So I think we've done this once before, maybe twice before. In the past, I haven't typically done it as often because before the moratorium was enacted, we had a lot more current planning applications that was coming before the Planning Commission on a monthly basis. So there wasn't really,
Time for this.
there really wasn't. To be
No
quite honest.
downtime.
In the last few years, we have undertaken a few very large projects, such as the comp plan, which took over 3 years, and then the clear and objective audit, which I think took about 2 years. Both of those projects thankfully have wrapped up. And then we also had the transportation system plan that took several years as well. So we had 3 very large planning efforts that have all concluded at this point. And with the moratorium going right now and it looking like there'll be at least probably another 21 months before we can take in any applications with additional ERUs and sewer connections. I thought it would be a good time to talk to the commission about kind of goals and actions for the next couple of years, especially going into the budget cycle here, because we're on a 2-year biennial budget at the city of Sandy. So how I laid out this document for you, if you've had a chance to look through it yet, is I laid out on the first page the background and context. I wasn't planning on going through all these unless you have specific questions around them. But in 2023, 2025, which we're still in that biennial budget right now, but we only have about 5.5 months left of it. I put about, I don't know what it is, 12, 13 bullet points of some of the major accomplishments, such as the comp plan, clear and objective audit, TSP. I also listed some other things, larger objectives that we've completed over the last 1.5, 2 years. On the second page of this staff report, I then laid out the department goals for the building division and the planning division, which are the two divisions within the department. The planning commission historically has been very involved with planning division, but not very involved with building division. I think for the most part, that will probably stay consistent in this biennium coming up as well, although I do have some things in the building division that I'll be bringing some code changes essentially that I'll be bringing before the planning commission for input and advice. Typically, if code changes are outside of Title 17, just so everybody is aware, they don't actually legally have to come before the planning commission. They can just go straight to city council for input and decision making. However, on some of the code sections, I want to kind of start changing that trend and getting planning commission more involved. As you'll remember, in 2024, I brought the sign code before you. And I'm working actually with Josh on refining a few last things on it. And then I'm hoping to bring it to the city council in the next couple months for a work session. And then hopefully a decision for revising the sign code. I think you also were involved in giving input on the dark sky ordinance, which is actually outside of Title 17 as well. And so moving forward, not every little code edit we make, but I do want to start getting more input from the planning commission on code and text amendments. And one of the main reasons is because as a commission, that's one of the main things you do, is you look at code and you interpret it and you give input and advice to both planning staff and then also make land use decisions. So going forward, as long as I'm the director here, I'll be seeking more input from the planning commission on more code changes, even outside of Title 17.
On the one for urban forestry, the city council had a tree committee at one time. Did they disband that or is it still going?
You know, that's an interesting one. So on this list, and again, I'm not going to go through every one of these unless you want me to talk to specific ones. I just don't think that's the best use of our time, me going through each individual bullet point. On a few of these, they've been kind of sitting out there for a long time. So the sign code, for example, I've been making edits to that and going back to the drawing board, I believe since 2018 on it. So it's been 7 years of hopefully adopting something new. Urban forestry, which Commissioner Lee just brought up, is another one where we've been going back and forth since I believe about 2019 on making changes to that code section as well. What did happen is the city council made an urban forestry subcommittee that met, I don't know, 5, 6 times. One of the problems with the subcommittee was that there was almost too many opposing voices in the room, in my opinion. So the council's objective at the time, and I think it was a fair objective, it just didn't work, was to grab some planning commissioners. I think there was 2 city councilors on there. And then there was some environmental activists or environmental folks on there. And then there were some developers. Well, as you can imagine, when we met in these little meetings right here at a table, those 2 groups that I just mentioned at the end could never really come to terms with one another. They were too far apart.
With our first tree ordinance that we had sort of the similar thing, except I appointed Bob Skipper, former sheriff, as the chair. So he
So you had
could,
oversight?
he could moderate the Brad picking and the
Yeah.
Susan Drew, you know.
So that I think that was, it was a really good idea. I just don't think it really worked.
Yeah.
And then honestly, also COVID happened. And then our priorities all got shifted to other projects like the comp plan and the clear objective of it.
Yeah.
So this time around, what I would propose for the urban forestry, for example, is I just want to work with the planning commission. And you guys can review things. Those will be work sessions where people from the public could submit written testimony, which then you could consider. And then when we move to a hearing, there'll be an opportunity for even more public testimony from the community. So if we have people on those 2 spectrums that want to comment, they'll have opportunities for that. But I think you as a decision-making body should really be making.
And we're not planning a big sea change to it, are we?
Not really.
Bring it in conformance with state and
So,
current established
so a couple big things.
best practices.
Urban forestry is an interesting one because it kind of overlaps to a lot of things in here. It also overlaps into wildfire resource and protection areas. So I do think it's a pretty important thing. So I think a few things on urban forestry, just to point out. There were some issues with the language not being clear and objective, and some of the language could be interpreted several different ways in that chapter. That was all clarified and all the issues were removed, as far as I'm aware, with the clear and objective
Right.
audit that we just completed. So that's been done. That was the biggest issue. The two other biggest issues, I think, with the urban forestry standards as they currently sit is the urban forestry section doesn't really protect groupings of trees very well, so we get a lot of developers that are proposing trees that are kind of standalone, and then they remove all the forest around them, and then we're having wind throw issues with the trees falling in big windstorms. So that's one of the big issues, is I don't think we should be allowing like 100-foot Doug firs that were in a grouping to now just stand out on their own.
Yeah.
And then the other big issue is, I think, in the past, we have allowed some urban forestry to stay within very close proximity to houses. And even if there's no wind throw issues and they're not gonna fall in the house, I think there's two issues still. We see a lot of times where there's tree branches that break off and damage the roofs. And then the bigger issue, I think, is if we were to have a wildfire event in this area, you have a lot of tall, mature trees that have a lot of
Potential.
fuel right next to some of our structures. So I think we have multiple things going on, but I do think the urban forestry section and updating that is one of our most pressing issues, honestly. And it's one that Patrick and I have to deal with questions on a weekly basis, from past land use decisions and also for upcoming tree removal.
It'd be good to
requests.
clarify.
Yeah, and then some of this stuff, as I labeled in here, has been stuff that the city council has kind of given me my marching orders on different code modifications they want to see, such as stuff around enforcement, outdoor burning, stuff that the city council has given input and advice on. And then some of this is actually retaining walls and fences, temporary structures and uses. We actually brought some of this before the commission in 2024. They gave us input and direction, and we honestly just gonna dig back in, make those modifications, and then get them back before you again for another work session. And then so taking all these goals that I've listed here on the second page, I've forwarded this already to city administration, and I've told them this is kind of my goal list. As as the director, I would say that it's missing one big thing, and that thing is gonna be pointed out here in a second on the next 3 pages. So what I then did is I went through Envision Sandy 2050, the new comp plan, and I went through every single goal and every single policy within there. There's a lot of them, as you all know. And I took out 21 of those policies because I think that's potentially a manageable amount to address over the next 2.5 years. I think if we get more than 20, I think it's gonna be just hard to tackle. And then what I did with those 21 policies, I divided them into 6 thematic areas, kind of like what we did with the comp plan itself. And so as you'll see on the final 3 pages of the staff report, I divided them into, I'll just kind of run through this. I divide them into economic development, housing choice and production, transportation planning, fire and natural hazards resiliency. And that's, I think, the big one that's missing from my goal list on the previous page. Water conservation and wetland and urban forestry protections. So to me, out of the comp plan goals and policies, these are the 6 thematic areas that I believe the Development Services Department and the Planning Commission can have the most influence over. There's obviously a lot of other important goals and policies in the comp plan around like parks, the Sandy Area Metro, Sandy Net, other public works facility needs. There's stuff around police in there. That stuff's all very important, and I don't want to minimize the importance on any of that. However, I don't feel on a lot of those, it's
more the
it's those other departments.
chief and
Yeah,
the
correct.
mayor who will see parks as a.
That's
Yeah.
correct. So I didn't leave those out because I don't find them important. I just want to let you all know. I left them out because I don't think they really follow
It's
under
not
the
our
scope of
purview.
planning.
It's not our
Exactly.
purview.
So that's why if you see something in here and you're like, wait, Sandy Net or Sandy Area Metro had a really important thing that I think we should accomplish. I don't disagree with that. I just, that department's gonna have to accomplish that. And as a board or as an individual commission member, if you want to give me any input, I would be more than happy to pass it along to city administration to share with the city council on those other objectives that are outside this scope. And then so within each one of those 6 thematic areas, I have several policies, at least 2 in each one of them, and some of them have 4 or 5. And then under that, I put together a list, and I worked with Patrick to put together a list of actions that could be taken to accomplish those policies and goals. So I think a good example of this would be if you take the 4th thematic area, fire and natural hazard resiliency. There's 5 policies that I pulled out of the comp plan, and then I put 3 actions for the next 2.5 years of things we could be working on doing. But and when I say we, I mean staff and the planning commission as body. And then from there, the last part of this staff report is the recommendation section. And basically, we just have a bunch of questions. These aren't questions that have to be answered. They were just questions that we thought that might help with this conversation here tonight and help with input and direction you'd be giving staff. So from there, I don't really have anything that I would recommend you guys have to do tonight or anything like that. I'm just looking for general direction, feedback, input. I know Patrick said he's ready to write some stuff on the whiteboard if you guys want to throw out other ideas that we didn't include or to refine some of these actions or policies that we did include. So yeah, Chair, I don't know if you want to kind of start us off with how you feel like we should address this, but it's open however you guys want to tackle it.
Yeah, first of all, thanks to those who submitted some of the thoughts ahead of time to kind of get us started. Maybe I was hoping to just kind of go around and get some brief thoughts from everybody on maybe what their top thing is or kind of where their area of interest lies. It might not necessarily be what you think is most important, but something maybe you would like to tackle most to kind of get you down into kind of start developing some priorities from that and kind of work towards what might be easiest and start the conversation from there. But kind of based off what we've talked about, just kind of go around and maybe pick a top 1, maybe 2 if there's something you're super passionate about. Just because you're on the side and in the first position, Jerry, I think I might want to pick on you and
Yeah, no problem. If I were to give the top 3 categories, not the red faction ones. And in no particular order other than the order that are here, would be housing choice and production, the fire and natural hazards resiliency, and wetland and urban forestry.
okay, you have a favorite?
Favorite of those, the housing choice, I think. And production.
Is there a specific kind of policy or action that you would kind of want to dig into?
One thing I've been thinking about on housing is we always talk about affordable housing and none of it's affordable. And I've wondered lately about are there creative ways that we could, with coding, encourage. It's a wild idea, like not necessarily tiny homes, but I'm thinking about a young out of college single couple who we want to attract to Sandy because they'll be here in 20 years and they'll be here.
Right.
For them to be able to buy a house that can gain value as opposed to being in an apartment. And just start small. I mean, we built a really nice 2-bedroom house at our office for, I think it's under 900 square feet. Whatever an equivalent 70 by 14 foot mobile home would be. And, you know, you don't have to be on a bunch of land, but if it would increase in value so that you could then turn around and move someplace else in Sandy. I don't know if we currently have the codes that would allow that. I don't know what it looks like. I don't know if other people are doing it. But that's just been a thought, a way for truly affordable housing that would gain value for a person who buy.
Right. It doesn't necessarily have to be subsidized housing. It's just something that
Right.
you can go out and purchase.
Where I came from before in California, that was called a condo. You bought a condo first, it increased in value, you sold the condo, you bought a house. But it's not the model for here, but
And there are condos in town, but they're just getting expensive.
yeah, even the condos.
One of the issues that we had in Westlake Village when I owned a condo for a while was the deferred maintenance on it. So there was going to be that aspect as well. And sometimes that can work for you and not against you. Like, for example, the roof repair. So not a lot of people that get their first home can afford to pay for, you know, replacing a whole roof. That could be a big cost, but I think 2-bedroom homes are a good start.
I don't think everybody needs a $500,000 to $600,000 house. There could be manufactured housing and other opportunities.
That's all that I've had for right now.
Thanks, Jerry. Jim?
Let's see, well, affordable housing is one of my top ones. It's something that the city council has talked about several times, but nothing ever occurs, so I think we need to really look at structuring some incentives to make it happen. And other cities like Bend are changing some of their enforcement requirements to encourage affordable housing, and some cities are giving a discount on the permit fees. So there's lots of people doing other things that would be interesting to do some research if staff had the time to do some research on what other people are doing. The second one is wildfire, because right now the Department of Forestry has put out their forestry wildfire maps, and most of Sandy is in the WUI section, which is wildfire urban interface. So even if you aren't in the highest, strictest areas, you still have to follow certain vegetation management plans, et cetera. And I don't know that we have any of that on the record as to what you would need to do to meet the state requirements. So I think we need to be doing that. And the third one is marketing for Bell Street to get some businesses into town, because if we can get more business financial support, then we don't have to count so much on residential development. So at one time there was discussion about having a part-time consultant do that kind of marketing rather than a full-time staff. And I don't know if anything has ever come of that discussion.
Well, we started off with having a grant position. PSU, we got a grant person who worked himself into a full-time job. And then when we had the moratorium, that job went away, which was the right thing to do. But it would be good to have someone help fill up some of the empty spots downtown.
Yeah, just to develop economic development, and there's new economic development, and there's kind of boosting.
Gainesville.
Boosting of what we have, or there's no reason that we can't promote our businesses more, we can't bring more people to stay in town at our
Well,
hotel and.
At the current moratorium, I think our move is to fill in the businesses that currently exist. We don't have the bandwidth to do a bunch of more ERUs with brand new businesses. We just don't. And it's not gonna happen, you know. It's a 21-month period, as Kelly said, to get to the point where whether they choose the option of attaching, you know, sending the big pipe into the Gresham treatment plant, or we, you know, go into the Sandy River. Either way, we're not gonna be lifting that moratorium for at least, if Kelly says 21 months, I'm saying it's gonna be more like 30 before we actually can start.
Time to do some
Right.
planning and marketing rather than
Right.
just sitting back and doing nothing.
Right, so if we do, there's enough empty facades in the downtown and enough. I think my idea would be to find out how many ERUs aren't being used that are still able to be allotted, which would allow for some building to happen now. And the natural resources, the forest and the wildfire prevention, like you said, we are in that area where we are the interface with, because of the wonderful boundary we have between us and Metro, that leaves us open to those, wildfire brush stuff that could come in. Heaven forbid we start getting heavy winds here. But I would think that that would be the fire and natural hazard resiliency would be something we want to address. I'm less concerned with the housing choice and production, even though it'd be nice to get that in place prior to the moratorium being lifted. We're not going to do anything with affordable housing right now because we don't have any ability to accept applications for new housing that doesn't already have ERUs attached to it.
Yeah, so now is the time to do the
To
incentive
do the-
planning. And get
Well, to
those
see what we
goals.
can do for the future. It's not something that's going to apply in this next biennium as far as bringing more money in to apply that affordable housing to. And then the other third thing I was thinking was working with the urban forestry and the wetlands and getting that the things where we can leverage other people's money to do the work that we want to do for Sandy. I did have one note on the safe schools thing that you had in there. Do we have any idea? Because I know we've done over the last 20 some years, we've done safe school projects. We've done the sidewalks to Sandy grade school. We've done the sidewalks to the high school. Where are the gaps in those safe routes to schools? And if we can find those gaps, and there are not very many of them, then we could probably leverage state money to complete that goal.
Yeah, so in 2019, I applied for Safe Routes to School facilities evaluation grant with the school district, and we got the grant. And so ODOT and the state of Oregon came out and did a very elaborative assessment. So if you go into this electronic copy, you can actually click on that 2022 plan link there,
Right.
and that'll bring you right to the plan that we had done. They identified about $800,000 to $1 million worth of improvements that are needed to bring us up to what they would consider full safe routes to school around the Sandy Grade and Cedar Ridge Middle School. So there's a lot of sidewalk gaps, there's a lot of hazardous crossings, there's a lot of lack of crossings, there's a lot of incomplete bicycle routes. You can go through that plan. I mean,
Is it
there's-
part of it because of those facilities abut Highway 26, Bluff Road, some major arterials? Or is it just,
That's some of it, but there's a lot of, I'll just be honest, a lot of lack of investment around those two schools. That has led to some gaps in kids safely getting to and from those schools. So for instance, my son walks to Cedar Ridge Middle School and home when the weather's not too bad. And he's even identified quite a few areas that he feels less safe in. So I think, going through that assessment plan, and we did it in conjunction with the school district, there is probably at least $1 million worth of facility improvements that could be done. And there's probably at least $300,000 or $400,000 work that absolutely needs to be done.
well, that would be where I would focus, is on the
Yeah.
one that absolutely has to be
So
done. Some of
so-
it can be accomplished with signage though, too.
So just so you're all aware, I actually did a Safe Routes to School improvement grant. So that's the second part after you do the facilities
Mhm.
assessment. I did that, I think, in 2021. Out of 90 something applicants, they picked 42 and Sandy scored 43rd. So we were one off on the grant, and that would have paid for 60. And so what I had applied for was $800,000 worth of improvements, and the state was gonna pay for 60% of that.
Oh.
And then 40% would have been locally funded. So I think one of the big things with that, just so you know, not to get into the weeds too much on it, but we really need the city council and the school district board to work together to come up with a cost sharing mechanism. Because what I don't want to do is apply for the grant again. And I know we'll get it this time around. I've already been promised stuff by the state of Oregon, by ODOT. But if I don't have the local match secured, I don't want to then have to return the grant award back to the state. So the city council and the Oregon schools, the Oregon Trail School District, they need to prioritize it if they want us to go for the grant money. And they need to work together as two two agencies to come up with a funding source. And then I'll go get the grant.
And it has to
We'll
be
get-
a fair, with our current administration, it's gonna have to be a fairness thing. It's not gonna be the city picking up 70% of what is.
And I agree. I
School
think it should be a
districts.
split. I think it should be a
Yeah.
50-50 split.
So what's the usual mechanism for funding that, like a bond or something like that?
No, it's usually the mechanism for funding is just like a maintenance. So the city has two.
Transportation fund.
Transportation or urban renewal were the two funding sources we use. The school district I know has a facilities fund, and then they also have, they have over, I think, $10 million in school excise tax that they collected.
Oh,
So I think, and I don't want to speak for either board or
Right.
the council, but I think they both have the money. I think it just is coming to terms with prioritizing safe routes to school.
Well, the other thing would be that, especially with like the Pleasant Street improvement, part of that.
That was part of the evaluation.
With
too.
the Pleasant Street improvement, you can justify the use of urban renewal dollars to do the sidewalks.
Exactly.
Yeah, they are also adjacent to the schools you want to get kids to, but it also is part of the urban renewal district that needs sidewalks for future businesses.
That's 100% correct.
Yeah.
And then I did want to point out just real quick before you guys keep talking on the clarity on the 21 month thing. So with the moratorium in 21 months, we will have enough ERUs for 190 more areas because the equalization basin at the treatment plant will be bigger. The long-term solution of having, I don't want to say unlimited
Unlimited,
ERUs,
but
but
yeah.
basically unlimited ERUs
To go to Gresham.
is probably 5 to 8 years away. I just wanted to clarify that if I wasn't.
A subdivision is how many ERUs?
Anywhere from 3, subdivision could be up just 3 lots. Or 4 lots, sorry. So
So
it could be as small as 4 ERUs and it could be as many as.
50,
infinity.
whatever. Yeah, yeah.
Or
You had
whatever you want to call it.
apartment complex. Yeah,
Yeah.
okay.
Darren, could we go back to you? We kind of skipped over you. It sounded like,
I think he might go. or
He
I was
goes
planning to go
last.
last.
Yeah, I
Oh, you
assume
were?
the chair normally goes
Oh.
last.
Two on camera too.
well, this is just an open
Prerogative.
discussion.
Yeah, no, but feel free, yeah. You can jump in.
Well, I was just gonna, I mean, if you do want to go last, that's fine, but it just you sounded like you started on an economic development as being your top priority. And then it went
Yeah.
Linda, so I don't know. But if you want to go back, because I'm looking, because I know you mentioned that, and I'm looking at your top priorities, and it is top 1, so I didn't know if you just did finish and got,
Yeah, I was just I think commenting on something and then I
okay,
moved to
all
Linda.
right, so then. Is it Brendan or Brandon?
Brandon,
Brandon, okay with that, okay, Brandon,
do you want me to go up next or?
yeah,
Oh, okay.
Yep.
All right, well,
And breezy.
so Kelly, you and I kind of talked a little bit earlier on the phone today about fire resiliency. So I don't know about you, but back in 2020, I thought my house was going to burn down. And I think a lot of people are kind of in the same boat where, we live next to this beautiful forest, but it's kind of a tinderbox waiting to go off. So one of the things that I was thinking about is, we have this 3 basin rule where we can only discharge into Tickle Creek during certain parts of the year. We already know that. But I guess the other question is are there other options for what to do with that water perhaps? And maybe one of those might be giving some of that to the Forest Service or, putting it somewhere where it can be used for firefighting, if it needs to be used in an area that's clear where, water can be scooped up. And I don't know if that's kind of overkill because we still have the Sandy River, but it was the thought that I was thinking about. And it kind of intertwines a couple things we're talking about, fire resiliency and in our 3 basin rule problem that we have. And then, of course, there's also, getting affordable housing going here too, is our restrictions on water discharge they kind of hand tie all the other stuff that we're doing. So that's what I'm thinking about right now.
So yeah, we'll jump online. Breezy?
I think this is a really good time for us to consider the water conservation stuff. I know water is really big for all of our community members. You see a lot of chatter about water issues with their water bills and all the other big complaints, and us focusing on some of the things that we could do for water conservation definitely would enhance some of those other pieces as we go through. It kind of to me, it seems to be a good funnel for all of the other steps. It's a great place to start if we're gonna have these things impact the way we handle our future building permits for sure. So that's kind of somewhere I think would be a good place for us to start. I also the housing needs, but I can absolutely see the reason for why we need to kind of wait for some of that stuff and prioritize other things. So that's kind of where I'm at.
Thanks.
Darren, just
Oh, sorry.
to add a little bit to that, Breezy, when you talk about water conservation, do you have any like starter ideas or something? I'll just say, me and Kelly had talked about just briefly was, the requirement for new housing, to have, a certain size yard or the yard to be landscaped rather than maybe going to like a hardscaping or giving options to cut back on the amount of landscaping that we're requiring. Cause that's in our control. But is there anything else beyond that you could think of?
I think the natural stuff and the mindfulness around impervious, what's impervious?
Surface.
We don't want a bunch of pavement and asphalt. We need the runoff, and we need all of the different impervious surfaces. We need to reduce some of those things, and the natural drought tolerant, the risk reduction types of things that we can ask homeowners and property developers to put in with the way we have housing go out. That alone, especially if we're going to bring young people in and we're hoping to have buildings that are being purchased by a younger demographic that are less maintenance and less expensive for upkeep, there's affordable housing. There's affordable piece to housing. So the three things that you have in the water conservation, I think, are all excellent things for us to really look at and think about.
Okay, thank you.
Are there standards for developing plumbing and faucets that drip or don't drip as much, a whole
Like low flow.
range of tools for that?
Yeah, I mean, you could. Yeah, like low flow faucets and toilets and stuff like that. Yeah, you could put, I think, more of that into your code. The tough part with a lot of the stuff around the water conservation measures, which I think is a good thing to pursue. I'm all for it, but I do think the one hard thing is going to be enforcement of it. The code can be very well written, and when we work with new developers, they can put low flow stuff in there and minimize the amount of grass they put in and everything else. But then when that home transacts and a new homeowner comes in, if they take all that out and replace it with stuff, it's gonna be, I'm not saying we can't do it, it's just gonna be very difficult to control. That said, I think it's worth the effort, because I think most homeowners are not gonna come in and take all that stuff out.
No.
And add grass and
This is
stuff.
saving your water
Correct.
bill.
I don't think most homeowners are gonna do that, but I do wanna just acknowledge that you will get some homeowners that are gonna come in and wanna rip out all the drought tolerant stuff and just plant grass. Or, oh man, this shower's not producing enough water when I shower, they take out that head and put, yeah. Like that Seinfeld episode where you had like the thing that was spraying so hard it knocked you over. So yeah, I think it's worth pursuing, but it will be a code enforcement challenge. Just to let you know.
Are there items we can do, well, for this water conservation and also kind of wildfire, kind of on a subdivision level, things, I don't know, the way that we grade things, or, require runoff to go into areas that could water, other plants in other yards, those types of things that the setup of the actual subdivision and how it's created that could help us solve these issues, or at least contribute to improving them. Maybe not on a lot level, but on a subdivision level where we have to have, wildfire wise, a gap of, wildfire resistant landscaping. on the outer edges of a subdivision, or if it's within so much of a forested area, or, you know, something along those lines.
You already have bioswales in your code, right?
We do, we don't have a lot of them in town. The one that I think they are great if people maintain them. And what I've seen so far in Sandy is not a lot of maintenance around them.
I was just thinking, just kind of what you said, if you picture a subdivision. And if the code was that all the park strips are they're gonna have street trees. But if the code was no grass. Just think how much water you could potentially save on, 100 homes.
On a citywide level, it would be a lot of water.
Or, you know, even just requiring sprinklers, you know, start with runoff from, you know, have a certain size tank that they pull from to start with, or.
Yeah, I'm not saying, and I don't know
Yeah.
any code that does
Do
that.
we,
And I don't
Yeah.
know, like, just,
Yeah.
you know,
And-
something along those lines.
And if you don't have grass, you need to have enough of a citywide maintenance program for the streets like that you drive, like Jewelberry or other ones where the developer's not continuing to maintain it. It's up to the city and you see the weeds growing up and there's no grass there, but there's plenty of under-maintained right-of-ways,
Exactly right.
and that can increase complaints.
Yeah.
Breezy Hill.
Yeah.
do we allow homeowners to harvest water?
Rain barrels, could I?
Yeah, we do.
Okay.
I don't,
Clarity for that sort of thing. I don't think our citizens know that. I don't think people understand how to do that. That's, you know, making sure our codes include encouragement for stuff like that.
For rain
Ti-
barrels.
typically with rain barrels, at least in my experience, which is somewhat limited, is that people that do that, they then hook that to a drip irrigation system. And then either they don't have a secondary irrigation system, or the irrigation system that comes off city water is only used in months where they're getting basically no water into their drips irrigation system through the rain barrels.
Maybe we encourage council to set some sort of educational system around harvesting rain barrel waters from your downspouts and how to use that in either irrigation or gardening.
Yeah.
That's more of a, that would be a outreach from the council.
Citywide initiative, yeah.
Yeah.
I know at one point through the state of Oregon, through the, Jan, you might know more about this, through like a water conservation source, you could get, I think, even like free rain barrel systems.
Mhm.
Yeah.
This is like 10-15 years ago. I don't know if they're offering that anymore.
Yeah, I think a lot of the programs that were available aren't anymore. But there are several pieces of legislation that are looking at beneficial use and water conservation that may be more forceful and enforcement related.
Were there places that were
I like carrots
prohibiting
more
rain
than
barrels
sticks.
for some reason?
Pardon?
Wasn't there certain places that were prohibiting rain barrels because it wasn't recharging
Right, yeah.
the well water?
Mhm.
More
Yeah.
rural areas, not so much urban areas, but I know
And there's 2 new programs proposed for aquifer storage and the program you were talking about to be expanded and to provide grants.
I mean, we could definitely look into it a lot more. Nothing saying we couldn't.
I think when you're talking about, like, Breezy was maybe the impervious surface, but if you were to. Then the impervious surface doesn't need as much, or like you were saying, no
Grass.
no grass in the boulevard areas where the trees are. But if you're gonna do that in anything like that, you need the potential to capture that rainwater. And you don't have to do it for a certain amount, but maybe that's a requirement you put on the developers. But it becomes some kind of reservoir system or something.
Build it into a sprinkler system.
Or it could be, used by the community as they could tap into it as a secondary source of water. But then again. Something that I haven't, thought about a little bit, but not certainly until the fires in California, is how prepared we are. I mean, if we were to have to fight fires coming up the bluffs, would we have enough water to fight that? Or should we look at an additional reservoir that you can gain from impervious surfaces or for these runoffs, just for fighting fires.
One thing I was thinking of, just kind of a story that we fight on the water conservation that can't be handled by code, but it's an attitude. I know a couple of years ago, if you look at my front yard, it is terrible. It's moss. My wife keeps telling me, just let it go to moss because you don't have to mow it. But I'll say this personally, that a couple of years ago, I disabled my sprinkler system. And I just had to go with the brown is okay. Where I grew up in upstate New York, hardly anybody sprinkled their yards. And in the summer, they went to brown.
Yeah.
And that's just the way it was. But we live in a culture where green is the god of the summer color. And I had to deal with that. So my line to people was I'd rather have a brown yard and air conditioning in my house, which we put in last year, but that can't be addressed with code. That's a philosophical, attitudinal thing.
Our front yard goes brown, but our backyard has a natural spring coming out of the side and it keeps the backyard green without watering anything.
Nice.
So,
So the cities of Bend and Redmond have incentive programs to take grass out and put in something else.
I've heard of
rocks
that.
or, yeah.
Well, on that line of incentive programs, I mean,
Walnuts at that too.
putting in
Push it
something
back.
that
Yeah.
tie it back into either water conservation or wildfire prevention. Having those things. So going back to what you were saying, Patrick, we're a little bit more prepared on kind of that homeowner level to fight some of those fires and self-defense on their own property, creating defensible spaces or home
Well,
sprinkler systems.
After the fires in California, people might be more receptive to that. View it more as a carrot to help protect them in the future as opposed to a stick to make them do something they don't want to do.
I think as Commissioner Lee pointed out too in her summary sheet is, I think something that a lot of people are continually forgetting about is, I think it's going to become increasingly hard to insure your home. And so that is the ultimate incentive, in my opinion, to create defensible space and everything else, because I don't think anybody that owns their own house would not want to be able to get insurance for it, so.
But I mean, is that a service we can provide as a city where we provide some kind of quick inspection that says, hey, these things have been done? And you can, who knows if their insurance will take it,
I don't know.
but
We do, the interesting thing is we do through floodplain management. I'm the floodplain manager for the city and we have to do things for them to be able to get insurance.
Yeah.
But oddly enough, there's never been anything around fire for that yet, but I do think it might be coming.
yeah.
Well,
Well, because there's the state of Oregon has that wild,
The one that Jim.
that Jan pointed out, and yeah, you go on that and that's gonna change. It's gonna shift.
Gonna shift insurance rates and insurance availability.
and we had a neighbor whose house was split in half by that tree. It was his neighbor's tree, but the neighbor's tree came down and cut his house in half, cost him $400,000 to repair his house. But he was told by his insurance that that's your one tree that fell on your house. Those 4 other trees your neighbor has, if they fall on your house, you're
You
not
don't
covered.
get another,
You're not covered.
you don't get another one, huh?
And
Oh,
the
wow.
neighbors don't have to take those trees down. And if those trees fall on them, they're not responsible.
Through the act of God provision.
Yeah. It's,
I don't want to lose, so I don't know.
we have
Art.
one more.
We need one more
Yeah.
from Art and then I'll kind of
Okay.
wrap up. Yeah.
I just wanted to make sure that you hadn't forgot that. he was on.
Art, are you still with us? I think you're on mute right now.
He's on.
We're ready for a yard.
I just stepped away.
Or we can go to you, Darren.
Yeah, I'll go ahead and go and a lot of.
Sorry about that. I was trying to figure out how to unmute.
No worries.
I thought I could just click on the little microphone, but I had to. Anyway, here I am. I don't really have anything to add to the discussion. I'm brand new to this and learning what we're doing, and Everything that I'm hearing makes sense. I don't have any commentary on it or anything to add.
All right, definitely understandable, yeah. All right, well, thanks. I'll kind of just, a lot, like I was saying, a lot of what I kind of are in my top priorities. It's already kind of been mentioned a little bit, so I'll just kind of comment a little bit in the areas that maybe haven't been. As y'all probably maybe or hopefully read, my kind of top priority was expand economic development. And this is specifically kind of mainly around the ERU piece. Is to have a plan to what we're gonna do with those 190 ERUs. Maybe that's more of a city council priority than us per se, but also maybe discuss code changes or plans for when that 190 run out, or what gets us through the next so many years until we do make that connection aggression or whatever ends up happening. Can these sewer problems be taken care of on site until that connection is available? Let's see, natural disasters. I think we talked a lot about the wildfire hazard mitigation, and this was a big piece for me. Another big piece is what happens maybe to prepare for and after a natural disaster happens, something like an earthquake or a wildfire. I recently found out that through my normal day job that most cities don't have the proper delegation for things like building assessments post-disaster, which is oftentimes needed for FEMA reimbursement, and having proper IGAs and stranded worker agreements in place so that way we can do those building safety evaluations and getting folks trained. Important to me, I spend a lot of my day thinking about, or a lot of some of the days thinking about, building safety evaluators and getting those plans. So,
And we do not have that, so we've talked a lot about it internally as staff, and we do have like our EOC we'd activate and stuff.
yeah,
But as far as building assessments, nothing yet. I
yeah.
just want to let you know.
Yeah, so kind of setting up those delegations of authority so we can bring in, because it's not something that the county is going to do. That's our responsibility. And by law, I mean, we can't let folks go back into their houses until they've had that evaluation. And so that creates strain on our sheltering systems that are going to be in place and our economic recovery, because if folks go and move somewhere else because they can't get back into their own houses, it just devastates an economy. So the sooner we can get folks back into their house, the better off we'll be as a city. But luckily, Oregon's making kind of progress in helping with some of these systems, and California is actually making their training for building safety evaluators free this month online. So getting those places and those plans in place ahead of time is super important. This one's just near and dear to my heart, but meaning the really financial resiliency of building and planning department as being in a planning and building department that is suffering great financial losses at the moment. I know how difficult it is because you still have work to get done. And so it'd be nice to try and create funds to where they can kind of weather downturns and also maybe have a little bit of backup to provide incentives for some of these other things that we've talked about tonight. And then I think affordable housing, just my other note on this was entry-level housing, I think, is one form of affordable housing, but looking to make other houses affordable, family houses affordable as well. I have one of those entry-level houses that was great for me to afford. I've been able to put a lot of equity in my house. That doesn't mean I can afford a proper, sized family house here in Sandy for what it costs right now. And so trying to figure out a way to just increase affordable housing as a whole and thinking outside the box. And one of the areas I was reading into that was popular in the way back in the 80s or so was to partner with nonprofits for like non-market rate housing, where essentially a nonprofit would not subsidize. No, it's not subsidizing, would buy houses or apartments or a condo building, build them, offer them at a market rate. But because they're a nonprofit that no longer has to make money every year, like a property management company, they keep the rates just at what they need to maintain the property. And so while in that first 5 years, you have a property that's market rate, come 20 years, you have properties that they're able to list for under. When you start saturating the market with these types of things, it helps lower the price of housing. So I don't know. That's a big ask. That's a huge ask.
Yeah.
You know, there's just tons of nonprofits with extra tens of millions of dollars sitting around that they're looking for something to do with. I know. But I guess my thought is to get creative about what that means for just housing in general and looking outside of just the normal.
Well, that's how Vista Housing got built. Was Catholic Charities, and 60% of the household income has to come from the nursery or farming industry to qualify to live there.
Yeah, so I mean, looking outside of just the normal, oh, it has to be a subsidy, oh, somebody has to be constantly paying, you know, somebody's rent every month, looking outside that normal system to kind of create affordable housing, and kind of what our options are there.
I feel very lucky to have gotten into Sandy on the ground floor.
Yeah.
When we bought our house in '85, it was $60,000.
Yep.
Sits on a third of an acre and is 2,000 square feet.
Yeah.
You couldn't get
I know.
nowadays.
Which is sad because I
Yeah.
have a 4 and a 6-year-old and I want them to grow up and buy a house in Sandy, you know,
Yeah, yeah.
and there's no way that that's, you know, possible at the moment. So.
I
Well,
noticed
68.
that new homes and subdivisions are between 600,000 and 700,000 now.
Just
Which is fine because that's maybe what I want to buy.
Right.
But we also need things for, you know, my
Yeah.
kids to buy.
Yeah, it's the interest rate really that screws everything up, because an interest rate on a 30-year mortgage on a $60,000 house, even say if it was at 8%.
Yeah.
Over those 30 years, that's not much money in interest compared to 8% interest on a $750,000 house.
Yeah.
On a 30-year mortgage.
Yeah.
It's just, it's not apples and apples. It's totally different world now.
And my son afforded his house in Westland just because they're on the GI Bill.
Yeah.
They both spent 20 years in the Army.
My uncle used to tell me about when he was buying his first house and their interest rate was 18%. You know, but again, like you were saying, big difference when it's a $80,000 house versus,
Exactly.
you know, a $700,000 house.
My parents' first house cost 1/4 of what our Tiguan, the Volkswagen cost.
Yeah, I just bought my 4Runner I bought a few years ago. My dad was laughing because it was more expensive than his first house.
First
that he
house.
bought, Yeah.
Yeah.
Oh, yeah.
It was like 20 grand, 15 grand more or something crazy. So Darren, I think, tell me if I'm wrong here as the chair. I mean, it seems like to me like fire and natural hazard resiliency, that was pretty resounding. Same with housing choice and production. Those were the top two that I marked at least from all the input.
And then water
The third
conservation.
one was economic development. And then the fourth and fifth were a tie between water conservation and wetland and urban forestry protections. And then probably last would be transportation planning would be.
Yeah,
There we go, then.
I want to say, I'll just, I think, add the note that while affordable housing was definitely in there and important for everybody, there was, I think, an acknowledgement that it maybe didn't have to be the first thing on the list.
We can slow walk that one.
Same
A
with
little
the,
bit more.
same with the Bluff Road rezoning of the Bluff Road, you know, designation as a commercial hub.
Yeah.
Nobody there is interested in doing that right now, so fast tracking, getting that zone changed where it's not
I
a
agree.
village anymore, it's not, shouldn't be top of list.
Yeah, and even if we did rezone it, they can't develop it right now.
There's no ERUs,
So,
yeah.
no, I agree with you. It's something we'll probably accomplish over the next 2 years, but it's not gonna be the first thing we're diving
Right.
into.
And by the time you want to accomplish it, different people may own those lots and they may have bought them with the
Yeah.
intent of doing something
True.
like that.
So one thing I would like to point out, just for all of your benefit, is the housing choice and production So as long as the city council or the city manager doesn't ask for some sort of exemption or delay, you know, we have to complete it by the end of this year. So that one will be prioritized
Because of the,
because of the
State mandate,
statute
yeah.
correctly. You know, one thing I do want to point out too, just for the benefit of this group, is that while I generally agree with the majority of the opinions on, you know, there's not going to be a ton that we can do for affordable housing over the next few years because of the lack of ERUs. There are a lot of strategies, and I think Commissioner Lee was pointing
Yeah.
to this. There are a lot of strategies that could be adopted that would then be applicable once we do have more ERUs.
right,
But
get our
even-
ducks in a row first.
Position us.
but but even more than that, there are strategies that the city could adopt to alleviate the burdens on current housing. So there are strategies that you can adopt as a commission and as a city council, if they so choose to, that could lead to like preservation of existing manufactured homes. Could lead to preservation of non-market rate housing. So you actually can create, I forget the exact term, but you can actually create zones that you can then apply on a map. Where they can't basically take out, let's just say, like the really nice manufactured home park that is on Strawbridge. It's one of the nicest manufactured home parks I've ever seen.
Yeah.
What I would hate to see, honestly, that's one of our last true areas of affordable housing and ownership in Sandy. What I'd hate to see is after the ERUs number goes up, that all get ripped out and new housing goes in there at $800,000 a house. So there are some things you could do like that as a city so that some of those affordable housing options don't go away. in 10
We can't
years.
do rent, what do they call it, rent control?
Yeah. So I'm not trying to point you guys in either direction or anything, but I'm just wanting to point out that there are some things that we could do over the next few years.
If we can get mass timber, right now is kind of expensive, but if that maybe in time starts to come down,
True.
that might be an option, especially for smaller, if they start looking at smaller, because they're manufactured, but the speed of production, you know, is a plus.
I like the
stuff going.
idea of tiny homes. A subdivision of tiny homes, I think that would be great, because that's come a long ways. The tiny homes have come a long way from when they
Well,
first
the other
started.
thing with mass timber is it's mostly, it is mostly spoke to as a manufactured house that can be manufactured quickly
Offset.
and replace a house so people can, like you said, get back into their house for, you know, shelter situations. You were talking, just get that rebound back. But actually, when I went to that, I went to this conference on it, it has a lot of resiliency to fire. Because of the thickness and how it's compacted, it will resist a wildfire. It will char the outside and then it won't burn anymore. And the fire will just go on, go
Seals
past
against it, yeah.
It seals against it. So there's that aspect of it too. So production, maybe smaller, less expensive house, starter home, but also you hit the fire and natural hazard resiliency too. So maybe
Combination.
it's something like that. Maybe that's something we can look at a little bit more and see how we compare those two together, because that seems to be the biggest thing on the list.
I wonder if it'll be easier to get insurance on that sort of housing as well.
Talking about mass timber, just an aside, my son has worked with a couple of projects in Bend with a company that's over here in Portland, maybe the one in Estacada. But a huge new library in the southeast side of
With
Bend,
mass
right
timber?
by the dump
Mhm.
landfill, is mass timber.
Well, isn't the New Gresham one there?
It looks like it.
Looks like mass timber to me.
I don't know if it is, but it looks like it.
Yeah.
Well,
It's a
Beaver-
cool looking library.
Is it Beaverton? They're building like a 9-story apartment.
Oh,
Oh, yeah,
complex
it's super
there.
strong.
Yeah, with mass timber, so. Yeah.
Well, I think it's only a matter of time before the price comes down, and I mean, time is money. It's like engineered trusses, you just have them delivered and installed, and all of a sudden you're done, you know?
Yeah.
Kind of nice to hear us using the word timber in Oregon.
So what's the tallest building we have in Sandy right now, Kelly?
I think the one in you mean number of stories?
Yeah, just number stories.
I think 3 stories is the tallest we have, although Cascade Creek, they're building, 2 4-story buildings right now. So I believe those are the tallest. Well, I don't know if they'll be the tallest, they'll be the highest story number of
In
stories.
residential, in commercial, we don't have anything higher than 3 or 2.
I don't know, I think we already have quite a few 3-story buildings in Sandy. Yeah, I don't know.
In the
about-
downtown.
I don't know about in commercial, that's a
Yeah.
good question. It might be 2.
Kelly, you promised us your top priority and then, maybe we'll see if there's anything else.
What's that?
What was your top priority?
Oh, my top priority is fire, natural hazards resiliency.
Maybe it's just because of the Palisades fire, but I would agree with that.
I think that's my top. I do think, I mean, everything that was discussed tonight is valid. I think I think everything in the comp plan was put in there as goals and policies because they're all good things to tackle, but with limited resource and time. I think the priorities that you've set are the top ones I would set. And around the transportation thing, I'll keep kind of chiseling away at that, but until the school district and the council meet and come up with a solution, I think we're kind of stuck until they do that. to
Can we
be quite
just
honest.
encourage that?
Yeah,
So
we
they've
could
joined
encourage that.
planning a meeting for at least 4 years. I know
Exactly.
of
So I have a
this.
question for you, Kelly. Did we have some sort of talk about like a facilities use agreement with the Oregon Trail School District? Because I thought I heard Kathleen say that, but I don't remember if I remember that correctly.
I think we do, and I think they're looking at modifying or refining that right now, but I don't know. I know as much as you do.
They like us to help them build their facilities, but then after they got them built and they own them, like the ball fields and that kind of thing, then they start
Yeah.
saying, okay, well, now we're not gonna share them with you.
Yeah.
You built it, thank you.
I know it's, I don't really get involved in that, I'll just be honest, but I do know that for some people in the community, it's a sore. It's a sore that doesn't feel right. That there's some like more collaboration and coexistence of using the facilities that needs to occur in the future. That has not occurred to date, from my understanding.
We get the blame, but not the credit for anything that happens, like they jettisoned their black hole of a pool to us. We realized it was a black hole and got rid of it, and then we get the blame for getting rid of the pool when it was actually the school district that realized it was not a viable. Yeah.
Kelly, Patrick, do you guys have what you need on this topic to?
Got lots of notes.
I think so, yeah.
We can put all our notes together in the next couple of days, get you guys something next week or.
So the next meeting is February 13th,
I think it's February 18th.
18th, yeah.
Real quick before changing
Yeah,
subjects,
just curious.
Commissioner O'Leary, I see you have your hand up.
Yeah, just out of curiosity, as I'm learning my way regarding the discussion about mass timber framing, how do we as a commission have an impact on deciding or encouraging or getting somebody to build a certain type of construction?
Don't want me to tackle that?
Go for it.
So I think the first thing would be is we want to make sure that the code
Oh.
is written in such a way that it allows for mass timber in all applications, which I think it mainly is. However, you'll hear on February 18th that there's some things we need to modify in that regard. And then I think the second part of it is two different things. I think you could choose to incentivize it if you wanted to, or you could just make it known that Sandy is welcoming mass timber and we've cleared a path in our code to allow mass timber in all applications. So I think there's several different avenues. But you're right, Commissioner O'Leary, it's tough to make anybody do it. And without sort of some incentives or the mass timber product coming down in price on its own, a lot of people may not choose to do it still.
I really appreciate that answer. It really helps me quite a bit. And so just to keep learning here, what is the benefit to Sandy to encourage mass timber construction here? Just to kind of be at the cutting edge, or use more wood because we live in a forest, or
I think,
why is?
yeah,
Go ahead.
I think what Patrick just pointed out were probably some of the top things. It's more hardy and resilient to fire, which is something I had forgotten about. I'm glad Patrick brought that up again. It gives us another source of, if there was to be a wildfire or some sort of natural disaster in Sandy, it gives us one more avenue of construction and maybe potentially a quicker avenue for construction.
For rebuild.
For rebuilding,
Right.
thank you. And then also, I think, generally speaking, I think more products that can be built in Sandy is just better for kind of the local economy and for options for our residents.
Yeah, I think another one, maybe not affecting Sandy as much, but you mentioned that 9-story building, it's quite strong and it's a renewable resource that can be used for those types of buildings where it might replace things like a steel structure frame.
What kind of roofing is used with that kind of a timber structure?
It's mainly metal.
Yeah,
That's what I saw in most of the pictures that we've seen.
yeah, it's mostly metal. But I don't think, I mean, it mostly in the sense probably for residential, there's probably definitely more stronger or different materials for larger span areas that don't use like trusses or pitched roofs, just because of the weight load that's gonna go on it. But because there's one thing about using mass timber, as you start to go up, the stands get bigger. They also get a lot heavier. So that's why there's there's limitations. There's so much science in it that I think they're still working at or figuring out for building higher. I think it was like a couple of years ago, it was just like people were daring to do 7-story buildings. Now they're daring to do like 12 and 14. So they're making progress on the overall strength of it. But one of the bigger things though too is, and this might go to having a city incentivize mass timber for coming to their city, is a pathway or avenue to get approval, because our building official, we've talked about this already, cannot. There's not building code written for a lot of the engineering that goes into mass timber. So it's going to a kind of an engineering / building code board at the state, and somewhere in that's held in Salem, that it has to go through there, and they do all of the approvals. It wouldn't happen on a local level. And you know, I don't think that's going to change anytime soon, because they have to rewrite so much code. So it's better is what happens with the builders of mass timber, they have it all engineered, and then they put it for another board of engineers that double checks them and make sure that all of the weight loads. Or right now, federal building officials or building building inspectors, they don't have the background.
So our code would say it has to pass X, Y, and Z boards before it can be used to.
Well, they almost circumvent the code. Because the local building codes are based off the state code. And state codes don't even talk about mass timber, but they have a provision to where it goes to this other engineering approval system that they approve it and they allow it. So, and I don't know what. Yeah, and I don't know what the liabilities are beyond that, but that's the kind of system right now. So the incentive would be to allow, like, so for instance, manufactured homes, they have their special little tag, they come out of the factory and they can just be brought and put on a site. But if you're building something, up from it, it has to go through a whole different system. But I think there's the hope that they can use these prefab mass timber homes in a factory, and they can come out and be built on site.
In like segments.
It's like a
Like a
manufactured
Lego
home
set.
is,
Yeah.
that is quicker and less expensive. There's still, I think, a lot going on there, but you know, we're trying to keep up on some of that technology or how it's adapting. And we're gonna get an expert to be part of that as well, right?
So I think mass timber is also known to be earthquake friendly, like it's very seismic resistant or whatever is another benefit besides the fire aspect. I will also share that I've been involved in several mass timber projects, and I have had the association walk through my job site when they had some conference going on in Portland. It's really interesting. I would just share my observation that industry being so new, my experience has been there's been a lot of promises. Then when the projects develop and we get into it, it ends up not happening. It goes to conventional wood framing or concrete. The rule of thumb I've learned is that the cost of mass timber framing is pretty similar to steel and concrete, but doesn't nearly approach what it costs to do a wood frame building. My experience isn't with houses, though. It's with large mixed use projects or apartment buildings. And we also were seriously considering a 10-story building, which would be the tallest at that time, 2 or 3 years ago, the tallest mass timber building built anywhere. So it's definitely an emerging technology. I think the industry might promise a little more than they can deliver. So we just want to always be diligent about that. And that stuff's moving fast. So the things I'm saying could be completely wrong, but I have been around significant amounts of it.
I totally agree. Going to that conference, I think they were over promising a lot of what they were saying.
Yeah.
That's it's very like promising. You're like, oh, this is going to be great. And where they get the wood from and how they process it, great. But you're right. They overpromise that the turnaround or this is going to be the next best thing.
Yeah.
And yeah, I totally.
Well, there's definitely some well-known actual disasters in the industry, but it's definitely something that's coming and it's maturing. And I think it changes fast enough that I'm confident to say these things that I'm mentioning are more just for information. And as far as I know, it could all be fixed right now. The other thing is there's some serious gaffes in the industry when we talk about pre-manufacturing stuff and delivering panels to the job site. In fact, there's a huge company that came out of nowhere named Katerra, and they built a massive CLT factory up in the Seattle area and one somewhere in Arizona. And they ended up going bankrupt. I mean, it was a hundreds of millions of dollars thing. So it's exciting to talk to them, know what's going on. That building that's being built in Gresham is cool as can be. And having something like that going on in Sandy would be fantastic. But it is a little bit of a sales job. It's cool that you've been to a conference, though, too. That's all really, really helpful. I appreciate the discussion.
Absolutely. Thank you. And I look forward to that work session on it to hear more. I think we were talking meetings for February. Kelly, I know we have the work session. Were we planning on having a planning commission meeting?
At this point, probably not.
Okay.
Just the February 18th.
Probably February 18th, and then I'll need to reach back out to you to talk about March.
Okay.
And what we can prepare for that as far as what we were discussing tonight.
Sounds good. With that one final, once again, welcome to new members of the Planning Commission. Thank you for being here. For those who have been here, thanks for showing back up again. We'll go ahead and adjourn the meeting 9:28. Thanks, everyone.
You.
How many years does this stand?